convene here the June 26, 2026 meeting of the board. And our first item, as always, is to have a roll call and establish quorum.
Member Andrews?
Here.
Member Bosler?
Here.
Member Countryman?
Present.
Member Griego?
Here.
Secretary Johnson?
I'm here. Good morning, everybody. Next item is introductions and announcements from our executive officer, and I believe we do have some today.
Thank you, Mr. Secretary. Chris Leaf, Executive Officer. I have two announcements this morning. First is a departure. So Vanessa Najera left the board's permitting section on June 11th as she accepted a promotion with the Department of Water Resources Flood Operations Branch. During her time with the board, she was a dedicated and valued colleague whose contributions will be missed. We're sad to see her leave, but we're pleased that she will remain nearby at the Joint Operations Center, and please join me in congratulating Vanessa on her new position and wishing her the very best in this new chapter. Second, we welcome Lucia Shari to the board. She joined us on June 2nd as an aide and will be assisting with our ongoing database records modernization efforts. Lucia brings valuable experience from her tenure as an AmeriCorps member based in North Highlands, as well as her work at Yellowstone and Acadia National Parks. Currently, Lucia is attending Sacramento City College to earn a certificate in applied apparel construction, with plans to pursue a graduate degree in public policy in the future. We look forward to her contributions to the database records program. Welcome, Lucia, and she's here in the back.
Welcome. I think you'll find our conference rooms are a lot like Yellowstone. So coming up on the agenda, we have approval of the minutes and consent items, public comment for items that are not on the agenda, legislative update, our placeholder for Corps of Engineers, which we don't have today, correct? And then we get to our first action item of the day, board item 9A, and that is enforcement order 2026-01 regarding Padra Tarifard. And that is, again, an action item. And then we have two cross-levee fence projects. The first one, 9B, is permit number 19916. And the second one is permit number 19806. And those are for Nadal and Silva, respectively. After that, we go to information items from the Department of Water Resources, including an update on the 2027 Central Valley Flood Protection Plan. That's 10B. And then 10C is an action item to approve the Delta Levees Maintenance Subventions Program estimated reimbursement summary and the 2026-27 funding allocation plan. Again, that's an action item. Following that, we have our usual items, staff activity reports, board comments and committee updates, discussion of upcoming meetings, and closed session. And my understanding is we do have a closed session today, is that right?
That is correct.
And that it is likely to result in a board action? Or may result in a board action anyway? And so that if it does, we'll report either way, but we may have an action to report, and then we will adjourn. We're looking at a reasonably long meeting today, I think. Not the longest ever, but longer than some of the ones we've had recently. And so I'm expecting that we will work past lunch and we'll take a break for lunch, or at least a long break, enough to get snacks and recaffeinate and such. And so we've also told the Department of Water Resources for the flood plan update and subventions program, that item won't start before 12:30. And so if you're here to observe those and not the others, you can check back then. Any questions or comments from the board about the agenda? Okay, hearing nothing, we move on to approval of the minutes. And if you're a member of the public who would like to comment, go ahead and raise your hand now. This is for May 22nd, and I've reviewed the minutes, and I believe they're in order. And I'll entertain a motion for their approval.
Move to approve.
Second.
Moved and seconded. Let's call a vote.
Member Andrews,
Aye.
Member Bosler,
Aye.
Member Countryman,
Aye.
Member Griego,
Yes.
Secretary Johnson.
Aye. The minutes are approved. Item number 5 is our consent items, and I'll ask our Chief Engineer, Michael Wright, to lead us through those.
Good morning, Secretary Johnson, members of the board, Michael Wright, Chief Engineer for the board. Today we have 4 items on consent. 5A is permit number 3823-4, a utility relocation for the California Department of Transportation Binney Junction project by Santa Fe Pacific Pipelines in Yuba County. 5B is permit number 19704, Alberta Road Bridge replacement by the Sacramento County Department of Transportation in Sacramento County. 5C is permit 19901, dry boat storage building by Alamar Limited Partnership in Sacramento County. And 5D is permit number 20049, the Fresno Slough new 12 kV crossing by PG&E in Fresno County. All items are in order. I've heard no objections from the U.S. Army Corps of Engineers or any other agency or individual.
Great, thank you. I will ask the public if there are any members of the public who would like to comment or request that I take any of these items off the consent calendar. And hearing nothing, do any members of the board like us to remove item? Okay. I will entertain a motion for the consent calendar then.
I'll move to approve.
Second.
Moved by Board Member Griego and seconded by Board Member Andrews, and we'll call the vote.
That was Bosler.
Oh, did I? Really?
Yeah.
I always thought that was funny when other people who have presided, are looking somewhere else and get the voice wrong because it seems so obvious. Maybe not. So we got the transcript showing seconded by Board Member Bosler, and we'll have the vote.
Member Andrews,
Aye.
Member Bosler,
Aye.
Member Countryman,
Aye.
Member Griego,
Yes.
Secretary Johnson.
Aye. Consent items are approved. Huh?
He's just being smart.
No hot mic moment there, though. Okay, item number 6 is public comment. And again, this is comment for topics that are not otherwise on the agenda. And as you all probably know, we don't engage in these and we're not allowed to take an action. We do appreciate folks coming here, and we ask that we keep it to 3 minutes if we have any. We'll start here in the room. Anybody who would like to make a public comment? Please approach the mic and state your name for the record.
Don Murphy. I live at 7260 Pocket Road. Actually, I'm here representing Billy Ann Groza, who is a cross-levee fence owner residing at 7454 Pocket Road. I've presented to the board before that her minor alteration fence, which was after her permanent fence was removed for the construction, that she has suffered nonstop vandalism, trespassing, and complete disregard for her private property. The city of Sacramento hasn't been able to do anything. SPD doesn't support sending people out because by the time they got there, the perpetrators would be gone. But I'm pleading with the flood board to come up with some kind of resolution that could at least provide signage on her property that it is in fact private property trespassing is illegal, and vandalism should be punishable by law. That's my comment.
Thank you. Anybody else here in the room like to make a public comment? And online?
Sarah Wolf.
Go ahead.
Can we give her the ability to speak, please? Sorry, one moment. Oh, yeah. You now have the ability to speak. Sarah Wolf.
Sarah Wolf, can you hear me?
Yes, now we can. Thank you. Go ahead.
Okay, great. Thank you. Sarah Wolf with Triangle T Water District. We are a water district adjacent to the Chowchilla East Side Bypass. And I'm just speaking to you today to let you know that we have successfully installed 3 fish screens to allow for diversions along the bypass in times of flood events. And we're very excited that and worked really well with the flood district and the lower levee district to get those in. And we look forward to working with the flood board and continue to work with the lower levee district on additional diversions and with our appropriate water right permit request before the state board and how we can move that project forward. But we are grateful for all the work that the lower levee district has done and the flood board. So we look forward to continued work together. Thank you.
Thank you. Thank you for that update. Do we have any other public comments online?
Susan Sells.
Yes, this is Susan Sells, and I am a resident of Sacramento County. And thank you for allowing me to do a public comment. I'm speaking today to voice the deep outrage felt by our community regarding the fencing and closure of our public bike trail access. It's completely unacceptable that a tiny handful of wealthy landowners are being allowed to effectively lock out over 500,000 residents of Sacramento County from a public tax-funded resource. These levees and trails belong to the public. They are vital corridors for recreation, active commuting, and community health. Allowing private interests to seize control of public access points sets a dangerous precedent. It tells the community that the privacy and privilege of a select few matter more than the right, safety, and well-being of hundreds of thousands of everyday citizens. This board exists to protect public safety and the public interest and not to shield private backyards from the community. I urge this board to stand up with the 500,000 residents of Sacramento County. Please review the permits of these fences immediately, halt any further private closures, and ensure that our public trails remain open, accessible, and welcoming to
Thank you.
everyone. Thank you.
Yeah, thank you. Reminder that this is comment for items that are not on the agenda, and we have 2 fence permits that are on the agenda. Do we have anybody else online who would like to make a public comment for an item that's not on the agenda?
No further hands raised online.
Okay. Moving on to our legislative update, we have a written update that's in our packet, and I'll ask our executive officer if he has anything that he would like to add or highlight from that update.
Nothing to add or highlight.
And board members, do any of you have anything that you would like to discuss related to the legislative update?
I just really appreciate it, and thank you, Chris and team, for keeping us updated on everything going on, especially at the federal level. There's just a lot of things that will have deep impacts, and so it's important for us to take stock of those as we do our work. So I appreciate the careful attention to that.
Thank you. That was Board Member Bosler, and I, Brian Johnson, heartily agree. Seeing no other comments, we'll ask Board Member Bosler to take her microphone light off. And Again, for item number 8, Corps of Engineers, we did not have a presentation today. So that brings us to item 9A, our first board item, action item, and this is for enforcement order number 2026-01 related to Padre Tarraford in Sacramento County. And I'll start here by just reviewing the procedure that we go through for a hearing like this. We will start with our board counsel administering oaths. We will have our board staff present the case in chief, questions from the board to board staff. And then we'll have an opportunity for the respondent, Padre Tarraford, and their representatives to make a defense, and questions for respondent from the board. And then we will have an opportunity for board staff to offer a response or rebuttal. At that point, we'll have public comment, if there is any. And then we will close the comment and move to a board discussion and possible motion. So with that, I'll turn to our board counsel, Jeet Dua, to walk us through the first step here.
Thank you, Secretary Johnson. Before I administer the oath, I just wanted to go over a few ground rules for those who are testifying today. Just to remind you, although that we are not in a formal court setting, that your testimony today still carries the force and effect of as if you were in court. We do have a court reporter here today transcribing what is entered into the record, and so it's important for people to not talk over each other so the record is clear. So I would ask that if you're being asked a question, wait till the question is asked fully before answering, and before the answer is finished, to wait to ask for another question. Please announce your name for the record when you come up. If you're still at the podium, you do not need to state your name each and every time. However, if somebody else comes up to the podium to speak in between, please state your name for the record. Also, I'd just like to remind people not to nod or shake their head or because that doesn't come across clear in the record. Please answer in the affirmative or the negative verbally. And with that, I'd ask people who intend to testify today to please stand, and I'll administer the oath. Thank you. And just, would you raise your right hand and just affirm that you intend to tell the truth today? Your testimony will be truthful. Yeah. Yes. Thank you. Thank you, Board Secretary. I'll turn it back to you.
Thank you. Did we provide guidance as to the lengths of the presentations for this item?
I believe the enforcement staff has some proposals for the board to consider.
Terrific. Okay, so with that, we will start with the case in chief. And my understanding is that Jennifer Scheck, DWR enforcement attorney, will introduce this for the others. Is that correct? Please approach the podium. Thanks.
Good morning, Secretary Johnson and members of the board. Ooh. Hello, 1, 2, 3. Thank you. Good morning, Secretary Johnson and members of the board. My name is Jennifer Scheck, and I'm an attorney with the Department of Water Resources. I assist board staff with their enforcement matters. I'd just like to give a brief introduction on the controlling law on this matter before Jenny 2 comes to present the case, if that's all right. Also present with me are Angeles Caliso and Jenny 2, and the matter before the board today is enforcement case 15719 against respondent Padre Tarraford, who is present with counsel John R. Garner, I believe. Hi, thank you. Next slide, please. Board staff are here to recommend that the board adopt an enforcement order against Respondent Hereford for 14 violations relating to an unauthorized boat dock, conduit, and fence at his property on the Garden Highway. Board staff also recommend that the board directs the executive officer to implement the order. First, the process of how we got to today. Next slide, please. The slide on the screen is here only to show the Water Code statute that directed the board staff in their process. This is Water Code 8701.2. In a few moments, Ms. Tu will testify as to her direct personal knowledge of the events in this case. Specifically, on August 5th, 2025, the board's executive officer issued a cease and desist order, which is also called a CDO for brevity, to Respondent Hereford. Now, the CDO ordered the respondent to remove the unpermitted encroachments by November 1st, 2025, and it was effective immediately on its issuance. However, Water Code above requires the board to schedule a meeting no less than 30 days after the executive officer's issuance of the CDO, and on September 26, 2025, this board heard from both sides and unanimously affirmed the CDO. Since the board affirmed the CDO, Ms. Tu will testify as to the 9 months of efforts that board staff made in attempting to meet with respondent to reach compliance according to the direction of the board and the CDO. During this time, respondent did hire a new engineer who submitted 2 after-the-fact reports, which together demonstrated that some regulatory standards were met. These included such standards as the required height of each of the boat dock pilings. So with the receipt and review of those 2 reports, 10 violations were removed, and the original 24 violations were reduced to just 14 remaining violations. However, it is noticed that up until today, respondent could have at any time removed all the violations, avoided all penalties, and avoided further enforcement actions by removing the encroachments and restoring the levee to its pre-construction condition. Next slide, please. So at this point, with the issuance and the affirmation of the CDO, and after 9 months of effort resulting in the reduction of 10 violations, the remaining 14 violations are established. And chiefly, I'll go into detail at the end, before the board today is whether to order the immediate removal of the encroachments, whether to impose administrative penalties, and for what amount those penalties should be. Board staff proposed order assesses a combined penalty for 14 violations and incumbent staff time at a total of $328,000. So how does one decide the amount of penalties? Next slide, please. Water Code 8704.1 states that in imposing penalties, the board shall express its rationale for the amount and specifically address the factors listed under sub C of section 8704. Water Code 8704C provides numerous factors for determining the amount of liability for each violation, which must be discussed in the board's findings and orders. Ms. Tu will describe each violation and the reasons supporting board staff's recommendations. The factors to be considered are presented in full on the slide, but they include the nature and circumstance, extent, and gravity of the violation, whether the violation is susceptible to removal or other remedial measures, whether the function of the levee channel or other flood control work is affected by the violation, the cost to the state of bringing the action. And then number 5 are a series of factors that respond to the person responsible for the violation. Any remedial measures undertaken, any prior history of violations, the degree of culpability, economic profits, if any, resulting from or expected to result as a consequence of the violation, and any other matters deemed relevant. Next slide, please. Today, this is an enforcement hearing, and unlike the CDO meeting, it is an evidentiary hearing. Evidentiary hearings shall be conducted in a manner deemed most suitable to ensure fundamental fairness to all parties concerned. The board may receive and consider all relevant evidence, which in this case means evidence that is the type on which responsible persons are accustomed to rely in the conduct of serious matters. Witnesses may testify during the hearing, although objections are not available by the other side, and cross-examination is permissible only if the board sees fit to allow it. Respondent was properly served. Board enforcement staff provided an enforcement packet with a proposed order and the staff report supporting that order to the respondent and his counsel on May 26, 2026. Respondent's deadline for the submission of a written statement of defense to the board was June 11, 2026 at 5 p.m. All documents, including written testimony and other exhibits for today, were also due June 11, 2026. Nothing has been received from the defense. The board may impose reasonable time limits at today's hearing. There was a proposal in the staff report for the time limits. However, board staff realizes that the original proposal led to a disparate amount of time between sides, and today offers the above 30 minutes for each side, 15 minutes for rebuttals, 30 minutes for public comment, 5 minutes each for closing. And I understand that the secretary has already prepared a plan, in which case we offer this for your consideration. Because the president or secretary may establish reasonable time limits for the presentation, and the time limit shall be known to all speakers prior to any hearing. I'm not sure if you want to count my time as part of the presentation.
We don't have to count your time as part of the presentation. It's setting the stage for all of it.
Thank you. And next slide, please. So Water Code statute provides for what the board may do today. The board decision. At the conclusion of the hearing, the board may approve, amend, or reject the proposed enforcement order, thereby take any of the following actions. Order the removal, modification, or abatement of the encroachment. Order the restoration of the site. Impose and require payment of administrative penalties. Order the recording of the enforcement order with the Office of the County Recorder. Initiate a civil action in the name of the state for mandamus or any other appropriate remedy authorized by law. Order any actions or conditions that the board may determine as necessary to resolve the violation and ensure compliance with this part. Next slide, please. Now, at the very beginning, I summarized, and I said that the board today must consider whether to order removal, whether to impose penalties, and for what amount those penalties should be. But I also promised that I would go in detail as to what those hearing issues are. And I've listed them above as 6 issues, which are also in the staff report. I don't think it's necessary to read them all.
I agree. We have them.
Okay, thank you. And with that, I can conclude. Does the board have any questions for me at this time?
I don't have a question, but if we can go back to the time allocations briefly.
Yes.
On the slide. While we're doing that, I'll say that I spoke to board counsel during the week, and we're going to accept this with one change. We will have 30 minutes for the prosecution team, 30 minutes for the defense team. We will have a 15-minute prosecution rebuttal. We don't have a defense rebuttal. We have public comment for the time that it takes. And the reason is because I don't think we need rebuttals and also closing statements from everybody. And so we're setting the closing first defense and then prosecution with an expectation of 5 minutes, but we'll make sure that respondent is able to have his say. Thank you.
Thank you. And with that, unless there are other questions, I will present Ms. Jenny Tu. Thank you.
Thank you, Jennifer. Good morning, Secretary Johnson and members of the board. I am Jenny Tu, Board Enforcement.
John Garner, I'm the attorney for Padre Terrafard. We just laid out what the itinerary was going to be, and I just want to be clear. Is this starting the prosecution's case? Then should we all come forward, or how? You didn't have anything on there for opening statement, so I'm assuming she's calling a witness.
Yes, we're going with all of the case in chief first, and then your presentation, including opening statement, and then evidence. And I think it's appropriate for people to sit at the tables here to the side. That's normally our practice.
Well, I didn't see anything on there about opening statements. So what I don't want is just have counsel testifying as though that's evidence. I want to make sure the record's clear on that. And you said the prosecution's case. We just want to make sure that we're, obviously the stakes are high for our clients, so we're taking this very seriously. But it would be my expectation they begin presenting their case. We'll go ahead and come forward, and presumably this is beginning.
Yeah, I'm going to turn to board counsel to make sure that we all understand exactly what's happening here.
Yes. Thank you, Secretary Johnson. We typically don't have respondent and then the prosecution sitting at the tables, but we can certainly do that.
I just want to know who the players are. So.
Yeah.
Okay.
That's fine. So
All right.
we'll have.
Well, if we want to object or if we have any issues that come up, certainly we have to have access to a microphone.
Yeah. This is not, we don't follow the typical court procedures with.
I understand you don't follow the court procedures.
Would you
but
let me
just
finish,
said
please,
what-
so the record is clear? We need one person to speak at a time.
Okay.
Thank you.
Thank you.
We just said what the procedures are. So we're going to adhere to the procedures that Mr. Johnson just laid out, correct?
Correct.
Okay.
Your client you will have an opportunity to speak on behalf of your client. Your client will have an opportunity to present its defense, both of you.
Okay.
The board will have an opportunity to ask questions of you. The prosecution team will have an opportunity to rebut any statements made by you.
We're doing rebuttals? I thought you just said we're not doing rebuttals.
The defense typically does not get a rebuttal, and it does
But you
not
do
happen
get a
in
closing
court.
statement at the end.
Okay. So the defense doesn't get a rebuttal, the prosecution does?
Yes.
Okay.
Yeah.
As is-
And your client
as is
and
you.
Ms. Caliso and Jenny Tu are under oath, and it is testimony, but it's not like a court proceeding. We present it, you present, and we go through like that.
I understand. I just want to make sure we're following it.
Great, thank you.
Yeah, okay. We'll go ahead and come forward. Thanks.
Just as a point of order, this is Jennifer Scheck once again, and I would like to remind my friend on the other side that Title 23:13.1 provides that there will be no objections during the testimony and no cross-examination unless the board deems fit.
Right.
Thank you. I'm going to look for a chair.
Yeah.
Good morning again, board members, Secretary Johnson, members of the board. I am Jenny Tu, Board Enforcement Section staff, who has been leading this case since the beginning through the CDO. I intend to guide the board through the facts of this case and how the agency's governing standards and requirements apply to the facts. We begin by confirming that the respondent and his counsel were provided with the required 30-day notice by certified mailing on May 27th, 2026, as shown postmarked in Figure 1. And in addition, a copy of the hearing packet was delivered by GLS and sent via email. Next slide. We briefly revisit the encroachments at the center of our discussion that was introduced at the CDO meeting. This is a vicinity map of the respondent's parcel on Garden Highway with the Sacramento River on the left and the Garden Highway levee on the right. Also shown on this map from an aerial view are the encroachments that include an unauthorized boat dock and 3 piles located in the channel, an unauthorized conduit on the berm, and an unauthorized parallel fence along the levee shoulder. The respondent, through a representative, Angelica Boso, submitted a board application to permit a boat dock and piles. The other elements, the conduit and fence, was not included in the application. The property is located on the waterside berm, bounded by the federal levee to the east and the Sacramento River to the west, and pursuant to Title 23, Section 6A, a board permit is required prior to commencement of any work. Next slide. At the September 26, 2025 CDO meeting, staff cited the respondent for 24 violations as shown as on Table 1, based off Water Code statutes and Title 23 regulations. Since then, staff has determined that 10 out of the 24 violations were verified to meet Title 23 compliance upon review of 2 after-the-fact record drawings submitted by the respondent's new engineer, Daniel DeGraff, who respondent hired after the CDO was in effect. The resolved violations are listed under the last column under compliance status. The 14 remaining violations and their respective Title 23 regulations include 6A, the need for a permit, Section 112A and B for constructing without board approval during the flood season, Water Code violations, Section 8700A for interfering and obstructing the performance, maintenance, and operations of the State Plan of Flood Control, and Section 8712 for unauthorized excavations made to the levee slope to accommodate the installation of a fence. These 14 violations are the primary focus of today's enforcement hearing. Next slide. Figure 3 are photos of the boat dock, conduit, and 3 piles identified in the CDO that were built without a permit. Staff determined that the boat dock was built twice the size of the initial proposed plans that were submitted through the respondent's representative, Angelica Boso. Next slide. Figure 4 shows a time lapse for the construction of the boat dock and 3 piles during the flood season, which occurs in the Sacramento area between November 1st and through April 15th, with no time variance request approval granted authorizing the work. Next slide. Figure 5 is a photo of the unauthorized wrought iron fence with 7-foot high columns and wood paneling that was identified in the CDO. Next slide. Figure 6 is a photo of a chain link type fence with metal posts that was there prior when the respondent purchased the property. This is taken from a Google time lapse dated January 2023. Next slide. Figure 7 is intended to show the difference in setbacks between the new wrought iron fence with the prior fence metal post that is still in place. To realign the setback of the new fence and to build columns, there would have been disturbance and excavations made to the levee to accommodate the installation of the new fence. Next slide. At the September 26, 2025 board meeting, the board affirmed the August 5th, 2025 CDO, requiring the respondent to remove the unauthorized encroachments by November 1st. Board also directed board staff to negotiate a potential settlement agreement with the respondent, temporarily pausing the CDO requirement to allow time for settlement negotiations. The settlement included 2 parts. The first part is that if a settlement could be reached, the board would give an opportunity for the respondent to permit compliant encroachments. The second part included penalties that would be imposed considering staff time incurred for bringing forth the action to the state and disincentivizing future noncompliance from respondent and the regulated community. Following the board decision, staff extended a settlement offer that reached no resolution, and board staff planned to bring the matter back to the October 24th, 2025 meeting to seek further guidance, but the meeting was canceled and the item was postponed. Next slide. The following day after the board's September 26, 2025 decision, staff happened to be on the Sacramento River and observed the respondent's boat dock we had new modifications that included a second shade structure under construction that was not identified as part of the CDO violations. Staff also identified later through the after-the-fact record drawings that a retaining wall on the levee prism was constructed to support the new fence. Because these additional encroachments were never disclosed to board staff, they were never considered into the board's decision at the CDO meeting and were not part of any penalty considerations. Next slide. The following slides is a chronology of events taken directly from the staff report, and so the slides are not meant to repeat every detail of the case, but to highlight the time incurred in bringing this action before the board today, and I'll briefly note some of the more important events. On June 8th, 2023, respondents representative Angelica Boso submitted a permit application for a boat dock and had ongoing communication with permitting staff and enforcement staff for a duration of 2 years. Next slide. On April 10th, 2025, USACE Regulatory Division made board staff aware they had issued a December 5th, 2024 NOV when they discovered the boat dock had already been constructed. Next slide. After staff was made aware of the constructed boat dock, enforcement staff prepared the August 5th, 2025 CDO. Next slide. On September 26, 2025, staff presented the CDO before the board where the board affirmed the CDO. Next slide. After the CDO meeting, staff had multiple communications throughout October regarding the settlement and the permitting the encroachments with respondent and his representatives that included a personnel assisting the respondent with the permitting process, the respondent's new engineer, and the respondent's prior attorney, Tom Terpstra. Next slide. On October 24th, 2025, respondents' prior attorney submitted a petition for reconsideration of the CDO, and staff prepared to come before the board for a petition for reconsideration of the CDO meeting. Next slide. On December 10th, 2025, enforcement attorneys held a meeting with the respondent's prior attorney to continue settlement discussions. Next slide. During the end of 2025 and going into 2026, subsequent settlement offers were exchanged between staff and respondent's prior attorney, and on 2 different occasions, staff met with his new engineer to review 2 after-the-fact record drawings. Next slide. On January 21st, 2026, staff responded to the respondent's prior attorney's petition for reconsideration of the CDO, and meetings between respondent's attorney and enforcement attorneys continued. On February 10th, 2026, respondent's prior attorney then requested an in-person meeting with board staff to discuss settlements. Next slide. Board staff removed the petition for reconsideration of the CDO from the March 27, 2026 board agenda, agreeing with an in-person meeting with respondent, his new engineer, and prior attorney to further discuss settlements. On March 13th, 2026, board staff and managers met with the respondents and the engineer and the attorney. On the same day, the respondent withdrew the petition for reconsideration of the CDO and requested an enforcement hearing. Next slide. On March 27, 2026, the respondent made a public comment before the board sharing his thoughts and stated that the board did not provide requested documents to him. To correct the statement, board staff provided the respondent and the respondent's prior attorney those requested documents on March 17, 2026. On April 2nd, 2026, a final counteroffer was presented to the respondent, allowing him to accept the offer by May 1st, 2026. And during this time, board staff also began preparing enforcement hearing documents. Next slide. And lastly, on May 7th, 2026, the respondent retained a new attorney, John R. Garner, who requested a continuance. Board staff granted the continuance and revised the enforcement hearing documents. Next slide. Table 2 is a summary listing the Title 23 sections and water code violations for the second shade structure and the retaining wall that we discussed earlier in slide 19. Those violations would have included Title 23, 6A, the need for a permit, 125A1, retaining walls greater than 3 feet in height must be designed by a licensed civil engineer, Water Code Sections 8700A, interference with operations and maintenance, and 8712 for unauthorized excavations to the levee. Again, these additional violations were not calculated into the assessed penalties. Next slide. This slide states that the board's regulatory authority is established under the California Water Code provisions listed in this slide. And through these provisions, the legislature has determined that the state has a primary and supreme interest in adequately protecting the lands from overflows, and therefore the board is empowered to establish and enforce standards governing the maintenance, operations, and protection of levees within the state plan of flood control. Next slide. Through the Sacramento and San Joaquin Drainage District, the board holds additional authority under a joint use agreement with Reclamation District 1000 sharing rights, which includes access, maintenance, operations, and protection of the levee and associated flood control facilities within the easement areas. Next slide. The federal levee at the respondent's property is part of the RD 1000 Natomas Basin levee system, consisting of 5 levee segments, approximately 41.84 miles long. RD 1000 Unit 1 is part of a larger system, 84 square miles, protecting population of 120,000 persons and property value of $6 billion. United States Army Corps of Engineers inspected the segment in 2010, re-inspected high-risk items in 2013, and will re-inspect in 2 to 3 years. Unauthorized encroachments would be rated unacceptable, impacting future inspection reports, and may lose PL 8499 eligibility. Next slide. The day before the CDO meeting held in on September 25th, 2025, the U.S. Army Corps sent a letter to the board reiterating the board's responsibility to regulate the flood control projects, stating unauthorized encroachments may inhibit operations and maintenance, inhibit emergency operations, impair the integrity of the project, and hinder project performance in times of floods. Additionally, unauthorized encroachments represent an unacceptable condition for levee maintenance and affect the eligibility of the entire levee system for rehabilitation assistance. Non-federal sponsors with operations and maintenance responsibilities for USACE projects are responsible for ensuring no unauthorized alterations are occurring within the project boundaries without prior determination by the USACE district engineer. This statement from the Army Corps of Engineers further supports staff's determination for a higher penalty in violation of Water Code Section 8700 for interference of the state plan of flood control. Next slide. Staff recommends that the board impose an administrative penalty of $328,000. In determining this amount, staff did not factor the maximum $50,000 per violation as authorized under Water Code 8704C. Staff would also like to note there is a calculation discrepancy in the penalty breakdown. However, as stated in the proposed order and staff report, the recommended imposed administrative penalty remains at $328,000. The individual violation assessment are as follows. Violation 1 and 2 for the boat dock were assessed at $25,000 each, totaling $50,000. No compliance has been achieved for this encroachment. Violation 4 for construction of the boat dock during flood season was assessed $50,000, as it carries a heightened risk to the state plan of flood control facilities, and thus work is restricted during this time unless board approval is obtained. Respondent stands to gain economic benefit from the boat dock, as having a boat dock would likely increase the home market value. Also, by bypassing the standard permit process and seasonal restrictions, the respondent gained the immediate use of the facility while avoiding the costs and wait time associated with regulatory compliance. This violation remains unresolved for this encroachment. Violations 5, 8, 9, 12, 13, 16 for the construction of the 3 steel pilings in the Sacramento River for the boat dock construction were assessed at $50,000 each pile, totaling $150,000. A higher administrative penalty because of the egregious nature of the violation, disregard for directives and impacts to the state plan of flood control facilities, and untimely partial compliance for this encroachment. Violations 17 and 18 for the conduit through the waterside berm were assessed $5,000, as they were considered lower risk to the state plan of flood control and therefore assessed a lower administrative penalty. Untimely partial compliance for this encroachment. Violations 20, 21, 24 for the fence construction on the waterside levee slope were assessed a higher administrative penalty of $50,000 because of the egregious nature of the violation and respondents' disregard for flood control safety by excavating into the federal levee embankment and risking damage to the state plan of flood control facility. Untimely partial compliance for this encroachment. These penalties specifically relate to the remaining violations to California Water Code Sections 8700A and 8712 and the Title 23 Sections A6A. Staff time was assessed at $28,000, spending a total of 350 staff hours between April 10th, 2025 and May 22nd, 2026. This does not include supervisors, managers, and executive level time, underestimating the full cost of resources expended by the state. Next slide. The CEQA analysis says adopting Enforcement Order 2026-01 constitutes an administrative enforcement action requiring compliance with law, general rule, standards, or objective administered or adopted by the board to address unauthorized encroachments within the state plan of flood control. By adopting the order, the preparation and submittal of a compliance plan and schedule will be required. The board retains full discretion to consider environmental impacts and conduct any required CEQA review upon consideration of the plan. Adopting the order does not approve or authorize any ground disturbing activity and is exempt from the provisions of CEQA under Public Resource Code Section 21084 and California Code of Regulations Title 14 Section 15321. Next slide. Board staff findings are that the respondent, as the current owner of the property located at 2931 Garden Highway, APN 2250210031000 in Sacramento County, is responsible and liable for the removal of all unauthorized encroachments identified in the CDO, to wit, boat dock, 3 piles, conduit, and fence on RD 1000 Unit Number 1, Sacramento River Federal Levee and Channel, a facility of the State Plan of Flood Control. The adoption of the enforcement order number 2026-01 is categorically exempt from the provisions of CEQA and under the Public Resource Code Section 21084 and under California Code of Regulations Title 14, Section 15321. The facts and conclusions as provided in the enforcement hearing staff report and its attachments are true and correct. The facts and conclusions as provided in the CDO affirmed by the board on September 26, 2025, as modified by the facts and conclusions as provided in the enforcement hearing staff report are true and correct. The respondent failed to correct the remaining violations as required by the CDO and is provided in the enforcement hearing staff report. Next slide. Therefore, staff recommends the board adopt Enforcement Order number 2026-01 requiring respondent to fully correct all violations as required in the CDO by removing the boat dock, conduit, fence, and by restoring the levee pursuant to Title 23, Section 120. The board adopts and incorporates by reference the facts and conclusions set forth in the enforcement hearing staff report. The board incorporates by reference the facts and the conclusions set forth in the CDO as affirmed on September 26, 2025, as modified by the facts and conclusions as provided in the enforcement hearing staff report. Respondent must submit a compliance plan and schedule for the proper removal of the unauthorized encroachment consisting of the boat dock, 3 piles, conduit, and fence, and for the restoration of the levee within 30 days of the effective date of this order to the board's executive officer for review and approval. No work shall commence until approval of this plan has been granted. Next slide. No later than October 31st, 2026, respondent shall remove all unauthorized encroachments identified in the CDO consisting of the boat dock, 3 piles, conduit, and fence, and restore the levee pursuant to Title 23, Section 120, as identified in the plan and as approved by the board. Respondent is required to pay $328,000 in total administrative penalties for the remaining 14 violations, including 1 staff member's time, as listed in the encroachment hearing staff report. The administrative penalty shall be paid no later than 60 days after this order is issued pursuant to the provisions of California Water Code Section 8704.1C. In determining these administrative penalties, the board considered and specifically addresses the factors set forth in California Water Code Section 8704C as presented in Section 7 of the enforcement hearing staff report. Next slide. If the respondent fails to comply with the board enforcement order by submission of a plan for the proper removal of the unauthorized encroachments within 30 days of issuance as required, the board may direct RD 1000 and/or contractor to remove the encroachments and restore the RD 1000 Sacramento levee and waterside berm to Title 23 standards, and then subsequently take actions to recover the cost of performing this repair by and all legal remedies available, including but not limited to the placement of a lien on the respondent's property pursuant to California Water Code Section 8704.1F and 8704.2. Should the respondent fail to pay the administrative penalties as required above and after the time has passed for judicial review, staff is directed to apply to the clerk of the Sacramento County Superior Court for a judgment to collect the penalty assessed pursuant to California Water Code Section 8704.1E. Staff shall thereafter take any and all available actions to enforce the judgment. Staff is directed to file a copy of the enforcement order with Sacramento County's Recorder's Office. Next slide. Therefore, staff is recommending the board adopt enforcement order number 2026-6-01 and direct the executive officer to take all necessary actions to implement enforcement order number 2026-01. Next slide. And does anyone have questions?
Questions from the board? Seeing nothing, thank you. And we'll go next to respondent.
All right. Thank you to the members of the board that are here. This case is exactly why you have boards. I don't think that board staff here necessarily intended to do wrong by my client, but I can assure you that temperatures are high, and essentially we think that we're here today because of a real simple mistake, and that is that board staff essentially collapsed the process on my client after the last hearing. I watched the video from the hearing, and it was you, Mr. Countryman, who actually asked my client, said, "Hey, it's a nice dock. Do you intend to comply with our rules? Will you go back and will you permit your dock after the fact?" And that was what the board asked my client to do, and my client said, "Absolutely." Now, we blame Mr. Dua for what happened next, although I won't hold him accountable for it. He said to this board, he goes, "Well, you have the power to penalize too." And the board said, "Okay, well, we didn't know that." It's right there in the video. The board didn't know that. And the board said, "Well, we direct board staff, it's in the video, we direct board staff to advise us on what this penalty would look like," okay? And in doing that, you essentially violated my client's due process rights in a really simple way. After the board hearing, the last board hearing in September, where my client was directed to go back and work with board staff, toot sweet, you know, because the environment's at stake and we want to make sure that we're doing everything right. Go back, work with board staff, permit your project. Board staff responded with a settlement demand and said, well, we'll approve your plans. We'll go forward, but you got to pay us $840,000. That was what their letter said. Now, everybody should have a copy of that letter, but I have 15 copies right here, and it's a letter from board staff dated October 3rd, 2025. I want to be really clear on that. Go ahead and permit, but you owe us $840,000. It's shame on board staff when you do that. That is the definition of extortion. We will approve your plans because there's no reason to remove your dock, but you have to pay us $840,000. Now, what's really interesting about the settlement demand dated October 3rd, 2025, is by board's own testimony, to the extent you can call that a case, to the extent you can call what Ms. Toot did a case to support penalizing my client, Mr. Terrifard, $300 and some thousand for his apparent gross malfeasance, you have to ask yourself, what evidence did they present? The reason it didn't get permitted is because staff wouldn't work with Mr. Terrifard. They said, you got to pay us $840,000. And it's right here in black and white. This letter was signed by Mr. Leaf, and it says that he's to stop any further work. He's to work on interim compliance. He's to submit a permit application. Why would you submit a permit application if this board hadn't already determined that there was a path to keep that boat dock out there? This board said, if you go back and watch the video from the last hearing, this board said, it's a nice dock. It shouldn't have to be removed. Well, the board staff didn't get their $840,000. So now it's got to be removed. We can't permit it now. That's what they're arguing. And there's no evidence presented at all to support removal of that dock, other than they're saying, well, you know, all this time's gone by and he didn't comply. He didn't submit a permit. No, that's not what happened at all. He hired an engineer. He hired an attorney that specializes in these types of things. Now he has to hire a litigation attorney because that's where this stuff heads. And that's why the government wastes money on attorneys and we waste time in court because, again, I started out by saying this type of case is exactly why you have boards. Boards hold the public trust. They're here to instill confidence in taxpayers and in people affected by board activities. And what the staff's done is essentially let this go off the rails. My client is sitting here today saying, I will permit the project. I will permit the project. I will permit the project. Let me be really clear. He wants to permit the project. He wants his engineer to work with board staff to make sure the dock is safe. That's it. Now, and again, I think it's just a simple mistake, but Mr. Dua says at the end of the last meeting, hey, you have the power to penalize. You're right. Boards have the power to penalize, not board staff. That is a non-delegable duty. And I want to make sure that that's clear in the record. We're informing the board. That is a non-delegable duty. That is not staff's duty. That is not staff's duty. That's the board's duty. The board does not have in its record anything to support at all that my client in any way deliberately failed to comply. That is not what happened. My client wants to comply. And all you have to do is read the October 3rd, 2025 letter to see that Mr. Leaf, by sending this letter, tied his compliance to paying $840,000. He can comply only if he pays $840,000. Nobody on the board remembers saying that at the last board meeting. Nobody on this board calculated $840,000 at the last meeting. And it's really, I mean, this is really important stuff. This is not a commercial business. This is a homeowner who bought a house on the river levee, regrettably, because he has a passion for boating in his spare time. And board staff says $840,000, you know, essentially the cost of a beautiful home for all of our staff time. Well, there wouldn't be so much staff time if they would just let him permit the project. So the board's already said, go back and permit it. Staff's already conceded that it could be permitted, okay? Why is it not permitted? because he didn't agree to the $840,000. And so our position is the proper course of action today is for the board to say, that's not what we meant at the last hearing. In fact, I forget which board member it was. One board member said, please move quickly on this. Let's get this permitted. Okay? The proper course today is, no, board staff, work with Mr. Terrafard, get the dock permitted. Clearly it can be permitted. His engineer has already submitted plans, already prepared plans. Board staff's already acknowledged it can be done. Board staff acknowledges in its own letter that it can be done. They're saying it can only be done, though, if you pay us $840,000. And that's what became the quagmire the last so many months. And so when these things don't resolve here, you end up in court, you end up on a writ of mandamus, you end up before a judge, and you say, look, judge, there's this little thing called due process. And due process implies that there's got to be a proper process to things. You're smiling, you're familiar, you're an attorney, you understand how due process works, and you can't collapse the process. You can't say, hey, homeowner, you get to use your dock, you get to permit your dock, but you got to pay us $840,000. And it's shocking. It's actually offensive because we're all members of the public. I'm sure many people sitting here today are members of the public. It's offensive. You know, Mr. Leaf, with all due respect, I'm sure somebody wrote the letter for you, put your signature on it, it went to Mr. Terrafard, but that was the real consequence. Mr. Terrafard, we know that you appealed to the board in September, and we know the board sort of agreed that the dock could stay. The board, just concerned with the environment, wants to have it properly permitted. That's not okay with board staff. You got to give us $840,000 too. So all this board has to see is where did your directive from the last meeting become a Frankenstein? Where did it get bastardized, if you will? Where did it go afoul? Well, it went afoul when board staff left disgruntled, feeling like, well, that's not what we wanted. The CDO says remove the dock. Nobody on this board directed the dock be removed after the last hearing. Nobody said that. That is not in the record. What was in the record was work with board staff to get it permitted. At no point in the record at the last board meeting did anybody say $840,000. You can ask Mr. Leaf, where did that number come from? And if it was $840,000 in October, why is it only $320,000 now? And that, ladies and gentlemen, is what due process is. You got to have an opportunity to comply with the law. And this isn't the first time this has happened in this case. You guys all are getting these packets. They're 2-inch packets, right? And there's a joke from Seinfeld where they say, well, lawyers are the people you pay to read instructions. They're the ones that are supposed to go back through documents. So I went back through the documents. And actually, before I even turn to that, I went to your website. You have the Central Valley Flood Protection Board Enforcement Authority, the procedures, the policies that you follow as a board, right? And board staff took it upon themselves to say in their first submission to you before the last morning, well, we issued a notice of violation. No, you never issued a notice of violation to Mr. Terrafard. This board never issued a notice of violation. Now, U.S. Army Corps of Engineers sent what the board is calling a notice of violation. They don't call it a notice of violation. Board staff calls it a notice of violation. Board staff never sent him a notice of violation. And according to your policies and procedures, the reason we do that, the reason we have this escalated enforcement process is because most people just cure when they get the notice of violation, which is exactly what Mr. Terrafard would have done. He would have cured. He said, notice of violation. Okay, cure it. People aren't putting in boat docks. He's not out there with a Susie take and bake oven and a hammer and some nails doing this himself. He's hired engineers. He's hired contractors. He's hired professional dock people to come out there. So if he gets a notice of violation, he goes to his contractors, his engineers, and the professionals he's hired, and he says, fix it, because I want to use my boat dock. And he fixes it. But board staff didn't do a notice of violation because this was all such a big hurry, right? They couldn't take time to do a notice of violation because it was such a big hurry. Yet here we are a year later, and the only reason that this isn't fixed as we sit here right now today is because Mr. Terrafard wouldn't pay Mr. Leaf's $840,000 that he put in his letter. It's not that big of a hurry. A court's not going to find that it was an emergency. A court's not going to find that there was any excusable basis to skip the notice of violation. Why wasn't a notice of violation sent? And it even gets worse. If you actually look in the documents that Ms. Tu put on the screen,
She put up a December 2nd, 2025 letter, and she highlights a portion of it. The paragraph above the one she highlights says that the U.S. Army Corps of Engineers acknowledges sending him an initial notice on December 5th, 2024. It says right here in their December 2025 letter, the notice was returned unopened to our office February 7, 2025. Returned unopened, February 7, 2025. What does that mean? The document they're relying on, saying it was a notice of violation, the December 2024 letter, was in plain English to the board, never received, returned unopened. U.S. Army Corps of Engineers telling board staff that. Board staff doesn't talk about that here. We never gave him a notice of violation. We skipped the step in our enforcement procedures. They're on our website that everybody in the state at least should have the I guess the benefit of believing that this board will adhere to its published policies and procedures, which board staff did not do in this instance. And it's not even just there. Jeffrey Wang sends an email to Stephen Lamb, and he actually says in this email, April 10, 2025, this is attachment 2. This was part of the packet before the last board meeting. Jeffrey Wang actually says, look, we sent a notice to Mr. Terrafard, but we never received it. It was never received. So the notice of violation was never received. Hold on one second here. It's actually in the packet itself. If you look back at the first packet from the last board meeting, the notice of violation, board staff took time to put the envelope in the packet. The envelope has stamped on it, returned to sender, never received. If they rely on it, you guys should be expected to rely on it. They put in their timeline, both before the last board meeting and before this board meeting, the date that the notice of violation was sent. Why? Because a notice of violation has to be sent in order for them to comply with your published policies. But it was never sent, it was never received. They never sent one at all. U.S. Army Corps of Engineers sent a notice that's not called a notice of violation, and it was never received. U.S. Army Corps of Engineers told them he never received it. They just omit that. So we skip right to it. We got to go right to a CDO. And so he comes to the CDO hearing, and he's told by this board, hey, will you go back, and like I said, I don't mean to focus on you, Mr. Countryman, but you asked the question to Mr. Terrafard. Mr. Terrafard, you want to comply with our rules? You want to permit your boat dock? You'll do those things, right? Yes. But you don't walk out of the board meeting and get a letter saying, hey, look, you got to do the things, but you got to pay us $840,000. I would like board staff to explain how they justified $840,000 as an extortion demand when they can't even come close to that figure today. It was $840,000 last October, but now they want this board to believe that apparently between October and then nothing must have happened. Board staff must have done nothing because the number didn't go up. The number went down to $300,000. I mean, that's borderline criminal in my opinion, that they're doing this to a taxpayer. They're doing this to a homeowner. They were doing this to a private individual. And that's why I started this by saying there are cases where you have board members. This is a board member case. The outcome today shouldn't be anything they just said. The outcome today should be, Mr. Terrafard, get out of here and as quickly as you can, go get your engineer, get in touch with board staff, get this thing permitted. Why didn't this happen a year ago? Well, they demanded $840,000 as a condition. They didn't have the right to do that. And we'll come back in 30 days, we'll come back to every board meeting from here on out, and we'll give you a status report. And that's how good things are. Every meeting, we will come back and we will give you a status report. Here's everything we submitted to board staff. Here's what they have done or not done. It's criminal that this has waited this long. It's criminal that this all came before the board last September and this isn't permitted yet. We're the ones that want to get this done and want to get it done quickly. He'll do anything to comply. But this board never told him to remove the dock. That was never the outcome. If that was the outcome, you'd remember it. You'd see it in the thing. They actually sent him in the same correspondence. Well, the CDO was approved. No, it wasn't. The CDO instructed him to remove the dock. That was not what you guys told him to do. And it was, like most board situations, you guys you're trying to do the right thing, and you explain it to board staff, and they kind of take it and they do their own thing with it, and we end up where we're at. He wants to permit the dock. That should be the outcome today. Go permit the dock. come back to us and report to us if it can't be permitted. I promise you it can. Then he can actually present what we call evidence, which he can have an engineer present to you. So you don't have to listen to me yelling at everybody. You can have an engineer in here who has a degree who tells you, here's why it can be permitted. And they can come and they can try to explain why, despite the fact that they were willing to let it get permitted for $840,000, they can try to argue why it shouldn't now be able to be permitted. And then we have a real hearing that actually advances public interest. Go permit the dock, Mr. Terrafard. It would be absolutely a gross miscarriage of justice for this board to issue any penalty today. No, this is board staff after the last hearing, you collapsed the process and you essentially took our responsibilities. As Mr. Dua said, you guys have the power to penalize. They do not have the power to penalize. Why? Because boards are either elected or they're appointed by electeds. They're not hired, okay? That's why you know, we refer to electeds with certain levels of respect, and board members with certain levels of respect, because you guys hold the public trust. You guys have the power to penalize. They do not. They do not have the power to penalize you to the tune of $840,000. Mr. Dua is probably Googling it right now. I swear to God, I see him on his phone. But I promise you, you do not have the power to penalize, or they do not have the power to penalize, the board does. And it's upsetting. I mean, it's upset. I mean, I obviously, like most lawyers, I know my clients outside of the office. I know Mr. Terrafard. I know how emotional this has been for him. They actually said to him at one of the meetings, you're rich, you can pay it. He sells boats for a living. You sell boats for a living. You're rich, you can pay it. That's what board staff said to him. Then when he wouldn't take their most recent settlement demand in, what was it, April, March? When he wouldn't take their most recent thing in March, they said, good luck with this, because when you finally do submit a packet to us, you're going to the back of the line. That's what board staff is saying to him when they're dealing with him, when they're showing up at his house with the documentation. The only thing this board has to say today is, Mr. Terrafard, get that thing permitted as soon as possible. And you hold the issue of penalties in abeyance. We'll come back. We can talk about it, and we can have a real hearing as to whether or not a penalty is warranted. And board staff can explain why, despite all their hard work and effort, it went from $840,000 last October to down to $300,000. So apparently they're working in reverse over there. Maybe we should applaud that. But what we shouldn't do is we shouldn't punish Mr. Terrafard. He's a tax-paying citizen. He's willing to play by the rules. He's got an engineer that already said he can do it. The engineer's already submitted something to them saying they can do it. They acknowledged he can do it. There's no dispute here. Just let him go do it. You just don't get to say, if you do it, you got to give us $840,000 because you're rich. They don't know. You've got a sick mom, for crying out loud. You can't just because he wears a polo shirt to a meeting doesn't mean he's rich. Just because he sells boats doesn't mean he's rich. And it's totally off base for the staff to say that to him at his home. Oh, you got a nice house on the river. You're rich. You can pay it. And in fact, just if we think about it as a board, right? You know, because typically a board, you're an elected or you're appointed by an elected, and you're asked to have common sense, right? And what is common sense? It's applying something to everyday situations, applying sound knowledge to everyday situations. Common sense, right? Well, common sense would dictate that if we're here as stewards of the environment, that we'd want to get the dock permitted right away. Forget about the penalty for a second. I get it. You know, we're in your sights on the penalty. I'm sure we'll be back on that, and this board has every power to hold that in abeyance and come back later and discuss a penalty. But wouldn't the thing that make the most sense be, can we get this thing permitted or not? Because the only way he's going to be able to pay you guys an $840,000 extortion penalty is to probably sell his house. But you can't sell your house with a lien on it, and you can't sell your house with an unpermitted dock, can you? So common sense, just simple common sense would say, Mr. Terrafard, go permit the dock, report back to us when it's permitted, so we at least have something out there that's not harming the environment. And then we can focus on penalties later. And as board staff pointed out, you know, you have the power to lien his house. He's not going anywhere. This isn't Up, the movie Up. He's not picking his house up with balloons and flying it someplace else. You guys will have the power to penalize him if that becomes timely and appropriate, and put a lien on his house, so you got complete enforcement. But right now, today, the best thing to do for the community, for the environment, for everything is go permit the dock. As this board pointed out, it's a nice looking dock. Board staff may not like boating. People liking boating might buy that house with that nice looking dock. There's docks up and down the river. And you know, we don't have to, I mean, we all are aware that you know, it's like the Sports Fishermen's Association, boating organizations. Sometimes the people that utilize our waterways are some of the ratepayers and fine payers and license payers and all those things that support our environment. I don't think that Mr. Terrifard wants to take his boat out on a river with eroded levees. No, he wants to comply. He wants to be a good steward of the land. He bought a house on the river. He wants to be a good steward of the river and of its levees. So all of this, we are here today. It is a complete miscommunication. It's an unwillingness on board staff's part to make this a linear process. One and then two. We got to resolve this permit issue. That's it. That's all this board should and can do today. Otherwise, if we don't do that, where do we end up? Writ of mandamus. We're before a judge. I guess it's off the board's plate, and you guys don't have to listen to me anymore. But that's not the best outcome here. That's not the right outcome. The board has already found the dock can stay. This board never said it can stay, but you got to pay us $840,000. Mr. Terrifard would like, I don't know how I'm doing on time, Mr. Johnson. I know Mr. Terrifard would like to say something. All of the evidence. What's that? So that means you have 8 minutes to, if you can do better. No, I'm just kidding. Well, then I'd like to let Mr. Terrifard talk, but I'd also like to open it up to questions because I think that's really the issue here. When Mr. Terrifard brought this to me and I looked at this and I said, well, this is, you want to permit it. Yeah, I want to permit it. And you got people in place to permit it for it. Yeah, I want people in place. But he can't permit it and have 300 whatever thousand, go permit it and then come back and let's find out if you owe us some money. Okay, at least now I got a house I can sell if I need to pay a $840,000 penalty. But at that hearing, you know, we can talk a little bit about whether or not staff's time got devoted to just spinning our wheels. Because I don't know how they got to $840,000. If they could only add up to $300,000 a day, I don't know how they were $840,000 last October. Mr. Terrifard, you can go ahead and.
We are allowed to ask questions. I recommend that you make your statement first, and then we'll turn to the board to see if we have questions.
My name is Ponder Terriford. Good morning, members of the board. Thank you for allowing me to speak today. I didn't know I was under time restrictions. This has been 9 months of my life, so yeah, this is a little bit longer than that. 9 months ago, I stood before this board myself with no preparation and no idea what was going on. I was defending my case against a team of engineers and lawyers who apparently spent hundreds of hours making a case against me. At the conclusion of that meeting, the board president, Dolan, gave clear direction. You instructed staff to work with me to permit the dock. President Dolan instructed the staff to work with me on completing the permit. I left that meeting feeling hopeful that we were moving towards a reasonable resolution and we would promptly finish the permitting process, which started years earlier. Unfortunately, what I received was an $840,000 penalty on top of the removal of the dock. Basically, this would be totaling well over $1 million in costs for me. They would not let me correct the permitting issue as you instructed unless I agreed to their penalty of over $800,000. This was not the start of a negotiation. This was the start of extortion. Staff advised me that they are basically basing the penalty on what they believe I can afford to pay, basically penalizing me based on my presumed socioeconomic status. Apparently, the staff believe I'm a billionaire or worth hundreds of millions of dollars. This is a simple question I asked Annalise Kalisko over a phone call. Do you think I'm a billionaire? I asked this on a conference call with Jenny and Annalise a few days after receiving the settlement letter. Annalise refused to answer the simple yes or no question. I asked it about 5 times. She absolutely refused to answer it. Obviously, I'm not a billionaire. At this time, I realized that this process was going to be an uphill battle and there would be little to no cooperation or collaboration from staff. Staff's only goal here was to make this process as difficult and expensive as possible for myself and the taxpayers paying their salaries. This is absolutely not about flood control or safety. At some point during the back and forth, the staff dropped the fine down to $200,000. Once they realized that I would be forced into bankruptcy over the last penalty. And we all know that there is nothing to extort if someone is bankrupt. I was told unless I agreed to their arbitrary figure, they would not let me permit the dock. The board cannot and should not delegate this penalty power. After all this, I was forced to retain an attorney, costing me tens of thousands of dollars for something that I never planned on getting an attorney for this. I didn't think it was needed. I'm fully cooperating. I've been in front of this board. I've done everything they've asked me to do. There should be no reason for me to have to retain an attorney. Then after months of back and forth, hiring an attorney, hiring an engineer, and spending tens of thousands of dollars, we finally held an in-person meeting in Sacramento. This meeting was a settlement meeting or a negotiation. That's what it was called. 8 people attended, myself, my attorney, my engineer, and 5 members of Central Valley staff, 5 Central Valley staff members, which most of them, 4 of them are here today. We spent nearly 4 hours discussing the case. After the end of those 4 hours, we were told exactly what we were told before. $200,000. We're not budging. This is not a negotiation. This is exactly the opposite of what this board has instructed the staff to do. I'll circle back to this later. Who am I? I want to remind everybody who I am. I'm not somebody who's trying to beat the system. I'm not a repeat violator. I'm not someone intentionally ignoring the law. I spent years remodeling this property. And just let's be clear, my previous construction experience was doing a kitchen remodel at my old house. Some countertops and some paint. I didn't even do it. I hired somebody to do it. That was the extent of my construction. I rebuilt this whole entire house. The house was built in 1952, and it had never been remodeled. So it was a big learning curve. During the roughly 2.5 years of remodeling this house, I obtained dozens of permits with numerous agencies. I hired licensed contractors. I hired engineers. I worked with dozens of inspectors. I followed the process. I made one mistake, one permit. That's it. There's no evidence that this was anything other than that. One permit out of dozens. One permit for a dock on a property that is permitted to have a dock. There used to be a dock on this property, a permitted dock. I remodeled the fence, a fence that stood on this property for over 60 years. Longer than most people in here have been alive. That fence has been there. 60 years of RD-1000 driving by this fence that apparently is a danger to society somehow. I paid for the permit. This is important. I did not refuse to get the permit. I did not refuse to pay for the permit. I actually paid approximately $3,000 back in 2023 for this permit. The mistake was I failed to complete the permitting process. This was a clerical error. State Lands gave me a permit for this dock. State Lands knew when this dock was going to be built. State Lands had nothing to say about it. I thought it was good once their permit came in. That is a very different situation than someone intentionally building something while trying to avoid government oversight. I acknowledge that mistake. I have acknowledged it from day one. I have repeatedly told staff that I will complete the permit and correct anything that needs to be completed. Now let's talk about the penalty. The permit costs about $3,000. Staff's original demand, $840,000. Think about that. A $3,000 permit, which was paid, became $840,000 administrative penalty. That's approximately 280 times the cost of the penalty itself, or 28,000%. Typical California after the fact permitting fees are 2 to 4 times. Basically, it should have realistically been $4,000 to $12,000 if we were looking at other California agencies. Even after reducing to $200,000, it is still an extraordinary penalty by every reasonable measure for a permitting mistake. I understand these penalties exist for a reason, but penalties should also be proportionate. This is why this board has discretion. Throughout this entire process, I have acted in good faith. I've never ignored staff. I've never disappeared. I've never refused to cooperate. I hired professionals. I attended meetings. I answered emails. I supplied documents. I repeatedly told staff, if something needs to be fixed, I will fix it. This has never been about refusing to comply. For me, it has always been about trying to reach a fair conclusion. Obviously, this is not the staff or enforcement division's goal in this process. I don't think the board fully understands what happened in our meeting in March in Sacramento. After waiting months for this meeting, after spending thousands of dollars on attorneys and engineers, and a couple $1,000s just for this single meeting to set this meeting up, cost me thousands of dollars just that one meeting. Nevertheless, that day I came in with an offer. I offered to pay $100,000 penalty, a $100,000 penalty. I also gave up my privacy of letting the Central Valley Flood come on my property at any time to do the inspections, and I gave up a whole list of things, of rights and things that I did not want to give up, but I gave them. Let me say something very important. I did not and do not have $100,000. I still do not have $100,000. This was not an offer made because I thought it was fair by any means. This was an offer made out of sheer desperation. I was willing to pay that amount that would financially devastate me simply because I wanted this nightmare to end. Staff wants this nightmare and this mental torture to continue. Staff rejected it. Surprise. They told me they were firm at $200,000. If $100,000 for a $3,000 permit could not even begin the discussion, then what negotiation was ever taking place? This meeting was not about a negotiation or a settlement or even an attempt to an agreement. This meeting was to wear me down mentally and financially, and the staff is wrong for that. And you should be ashamed of yourselves. What you've all done to me is absolutely wrong, and you should never do this to anybody else. Nine months. 9 months, this case has consumed my life. Financially, emotionally, personally, professionally. It has affected my business. It has affected my family, my sleep, my health. Every day for the last 9 months, this has been hanging over my head. That has become my punishment. Intimidation. Shortly after I was presented with the original $840,000 offer, I asked Miss Annalise Caliso a simple question. What happens if I can't pay? Since I'm not a billionaire, I can't pay. I do not have that kind of money. Her response to me was that the agency would audit my assets and seize my assets until the penalty was paid. So an example would be my cars, my home, my boats, my furniture. I don't know where it stops until the penalty's paid. This is typical of what happens to drug lords, mob bosses, criminal enterprises, and other hardened criminals who unlawfully make their money. I have been treated like a convicted criminal.
Excuse me. We're about 5 minutes over, and I'm not cutting you off because I want to make sure you have a chance to say. Do you have an estimate for how much longer we're going to be here?
A few more minutes, about five to 10 more minutes. for the penalties being charged, they could wait.
Go ahead.
Whether this legal collection was a final order or not, it's not the point that I'm making. The point is how that conversation felt. Imagine receiving an $840,000 demand after never dealing with the government, after never dealing with the wrath of the government, and then immediately being told that your assets could be audited and seized. That did not feel like a collaborative effort to solve a permitting issue. It felt like overwhelming pressure. It felt like extortion. Pay up or else. Transparency, or in this case, the lack of transparency. Beginning in January, we submitted multiple requests asking one simple question: how have others been treated? Who else has received penalties like this? We want to compare similar cases. We wanted transparency. To this day, we have never received the information requested. They did send us something. It was useless information. I don't know why they even sent it. If this penalty is consistent with past cases, then the record should show that. If it is not, then this is proof of prejudice, bias, and injustice that has been happening. I believe that this is the case. And they would have provided simple information that we requested, but they refuse. Another issue that deeply concerns me is the targeting. I feel like I'm obviously being targeted. Staff contacted the Department of Transportation regarding my fence. They took time out of their day, out of that 320 hours, somebody here, and called the Department of Transportation on the fence. Basically something about the fence line or something. I don't know why they took, Department of Transportation can do their own jobs. Yet the staff took time out of their day to make sure that they reached out to a completely unrelated government agency in hopes of them harassing me and giving me a hard time. I would like to inform the staff member that the tactic failed. DOT did visit my house with 2 inspectors. The inspectors basically told me that they have better things to do than to deal with a fence line that nobody is affected by, nobody is complaining about, and frankly, nobody cares about. Way to waste more taxpayer dollars. This referral reinforced my belief that I was being singled out for extraordinary treatment. Public agencies should not use their authority to protect the public and work towards reasonable resolutions, not to create additional obstacles and hardship for a single citizen. To me, this demonstrated an effort to make my life more difficult rather than to serve any legitimate public purpose. What is this case really about? This case is about a fence and a dock, not a collapsed levee, not flood damage, not environmental destruction, no injuries. No flood occurred. No one was hurt. I understand that these facts do not eliminate the permitting requirement, but they do matter when considering what was fair and proportionate outcome. Today needs to be the end. Not another meeting, not another letter, not another 9 months of hell that I've been put through. I have nothing left. Financially, I am done. Emotionally, I am done. I cannot continue living like this. I cannot continue paying attorneys. I just can't continue doing any of this. Like anyone else, I have made mistakes. We all have. But it's not the role of the government to ruin someone's life over a harmless mistake that caused no injury, no damage, and no public harm. Government has an obligation not only to enforce the law, but to exercise its authority with fairness, proportionality, wisdom, and humanity. This is what I'm asking of the board today. I ask you to look beyond the paperwork. I ask you to use your judgment and discretion entrusted to you to bring this matter to a fair and reasonable conclusion. Enough is enough. I'm done. You guys can ask me whatever questions you need to.
Thank you. Questions from the board? a board member Countryman, and he'll tell you which who it's for.
I'm kind of mystified. Have you ever submitted a complete application for the dock and for the fence?
Yes, originally we submitted, when I originally did that in 2023, the application was submitted. And I hired professionals at the time to do it. And I've hired professionals after the fact to do it. They agreed that the dock is built to standards. It's not only built to your standards, it's built over standard. Everything was in line. There's nothing that needs to be repaired. And I think that the staff was not ready for that. Everything's good to go. It's been resolved. It's just they want money.
Well, a follow-up on that is my understanding, maybe I'm wrong, you can correct my thinking here, but the dock that was built was not the dock that you provide plans for and so forth.
Yeah, the geometry of the dock did change once it was actually built, but we have as-builts on the current dock.
So, you know, when you were here last time, and you were very persuasive, if you have plans and everything showing that that dock is compliant, that the piles are compliant, has the board acknowledged that? Has the staff acknowledged that the plans you provided meant what they required to review it?
Yes, the plans were submitted. I mean, Mr. Wright's right here. Everything's compliant as far as I know. They didn't, the board, the staff never told me, nobody ever told me that there was something wrong that needed to get fixed. So I assume once these plans were submitted many, many months ago, that they are good to go. This is strictly a money issue right now.
So since the time you were here last time, you have submitted a set of plans showing what the constructions were with the piles and the dock, and the board staff has that?
Absolutely, yes. Those were submitted many months ago. And like I said, as-built of the current dock and everything needed, everything asked of us. They went back and forth a few times. He had provided all the information that they asked for, and everything seemed to be compliant to my knowledge.
So it's your understanding that you provided all the necessary documentation for a permit to be issued to you on the dock? I just want to get a clear understanding of that.
As far as I know, yes, but I don't know if they're holding something back. I don't know. Staff, I don't know how these processes exactly work, because staff told me in the meeting in March that I need to submit a new permit process and start basically from the back of the line and start the whole process over. So if I didn't pay the fee, essentially, I don't know. I don't know what they want.
Well, of course, I'll ask the staff later to confirm what you said. Thank you.
Through the chair.
Board Member Griega, your mic's on, by the way.
So, Board Member Countryman just asked about the permit, including the fence, and it's my understanding that the fence wasn't part of the original permit. Do you want to clarify that?
I never knew that there was an issue with the fence when like I said, it was a 60-year-old fence. It was built right there. I never knew that that was a thing.
You know, you're a pretty intelligent guy and you articulate very well, and your complete property is on the water side of the levee. Everything you do on that side of the levee has an impact about how the flood operation runs. That's the reason for my question. The other part of my question is, you put up a shade structure all while this was going on, and through the communications with our staff, you continued to add to the project more money, and I think hard to realize for us that you were going to stop, the project until this was resolved. So can you explain to me why you continued on with the project?
The day after I came here, I stopped all construction. I literally stopped. President Dolan at that meeting said no more paint, and there's actually rusted parts on that piling that I wanted to paint, and I did not paint. I stopped when I was told to stop by this board. I stopped everything, and there's an unfinished shade structure there right now, 9 months later. So I did stop.
So the shade structure wasn't part of the permit, was it? It wasn't included on the permit as far as the work goes?
I think it was submitted on the as-built for the current dock. That was submitted to them. Yes, I believe it was.
Okay, thank you.
And that, just to follow up to that's been our whole point, and why the lack of a notice of violation is it's unclear why that was never done. Because certainly you have a notice of violation when there's something like a shade structure that be an issue. It's our position it was originally submitted, but what I'm trying to point out is that goes to the whole collapsing of the process. The board staff just chose to a notice of violation, which would ordinarily be done in a situation like that. And there's no good reason why any homeowner would not correct after receiving a notice of violation. Just here, there wasn't one.
Just want to remind people to state their name for the record when they're not the same person talking, and just want to confirm with the court reporter that you were able to capture that. Thank you.
Thank you.
Any more questions from the board? Okay, thank you. That concludes your part of this, that step, and we'll go back to the prosecution team for a response and rebuttal.
One, two, three. One, two, three. Thank you so much. Again, my name is Jennifer Scheck with DWR, assisting enforcement staff. I'm only going to take less than a minute here. I want to address a couple of things that my friend on the other side said. First, there were no due process violations. This is a fair hearing. He has been properly noticed for every meeting and hearing, and he has adequate time to express himself and to be heard. Second, as far as a notice of violation not having been issued, there was a cease and desist order that was issued, and it was issued because it would be futile, unlikely to result in unreasonable delay, and unlikely to prompt timely corrective action. There was a process by which we went straight to CDO, and it was explained at the CDO meeting. Respondent did have a petition to contest that CDO, and he withdrew it. Again, for the due process, defense did have an opportunity to submit any materials and a statement of defense before this meeting, but he missed his deadline. I'm sure the board would have allowed him to express himself fully if he had some sort of writing. And then finally, I believe the board staff does categorically deny every civil and criminal allegation of extortion or any other crimes. Thank you.
Good morning, board members. Angeles Calizo, Board Enforcement Section Manager. Thank you for your time. I wanted to address a few points that the respondent and his attorney have brought up during their testimony. First, I'd like to start with pointing out that this whole process could have been avoided by the respondent completing the initial permitting process that was initiated in 2023 and completing that application process. During that application process, the respondent, through his agent, was made fully aware of the process and where the application permit was at the time. In a communication from his agent on April 17, 2025, she stated to board staff, upon receipt of your November 20th, 2024, with the incomplete matrix, I spoke with Padra Tarifard, regarding your requirements for the completion of the permit process. He decided to handle the permit process himself from that point. This was part of the CDO in attachment 2. The respondent never made any attempts to contact board permitting staff to follow up on the status of the permit application. The respondent and his attorney have categorized the behavior and the encroachments as a simple administrative error. I want to point out this is not an administrative error. The encroachments that are considered here by the board are significant alterations to the state plan of flood control facilities, and they have been documented in the staff report. These encroachments, as Ms. Tu testified during her presentation, carry an impact to the ability to retain federal eligibility by the Army Corps of Engineers for future emergency repairs to the state plan of flood control facilities. The board's role in this matter and the responsibility is for regulating encroachments, and encroachments regulations functions fundamentally as a preventative measure. That's the whole point of why the board is here. The regulations are intended to provide the process to mitigate for those encroachments to be evaluated through that process. And that is before any of the work is undertaken. The respondent here has failed to follow through that process and those analyses. Each of these encroachments that are unauthorized carry the risk for having the impacts and being detrimental to the entire state of a plan of flood control system. The respondent also noted and spoke about, his plans and the submission, the as-bills after the fact being full compliance with applicable regulations. He's partially correct in that some of the violations, applicable Title 23 violations, have been demonstrated to be in compliance. However, I would remind the board that this determination is partial because part of the board's permitting process includes the Army Corps of Engineers 408 review process, which at this point has not been initiated nor started as well. Furthermore, we want to point out that after the issuance of the CDO, and through the submission of those as-built plans, staff discovered additional elements and non-compliant encroachments that Ms. Tu presented during her presentation. And those include the retaining wall that was built below the existing, to support the existing fence. That requires some significant alterations and modifications to the levee. Additionally, during the settlement discussions, the respondent's engineer disclosed that the old piles that existed in the channel had been left in place. This is an inappropriate condition, and again highlights the need for the permitting process to be followed, allowing the board to do the proper review, evaluation, and proper construction oversight. None of those steps were followed, and the board did not have the opportunity to conduct a proper construction oversight. So doing an after-the-fact permit carries challenges because of these situations. Going back to the respondent's statement about the settlement agreements and how he characterized the engagements through settlement, the board's directive at the CDO meeting was that they affirmed the cease and desist order as issued, which required the removal. However, the board wanted to allow the respondent to possibly permit the encroachments, to retain them if he would be able to show compliance with applicable codes. But in addition to that, he would be required to negotiate a penalty that would account for deterrence and noncompliance, and that was a direction for the board. That was a directive that staff took through those engagements with the respondent. Through the settlement discussions and negotiations, the respondent continues to highlight the initial engagement to the respondent. I want to note, and for the record, that the settlement offer that was presented to the respondent was a fraction of what is here before you today. And it included other terms that ensure future compliance with the respondent, the opportunity to secure a permit going through the permitting process. The $840,000 the respondent continues to speak to was made clear that that was not on the table and that was significantly reduced to a much lesser amount. The respondent also spoke about his offer of $100,000. That was incorrect. The offer was only $30,000 with his willingness to pay $15,000 and an additional $15,000 over a period of 12 months. The additional and again, the respondent opened up the door to the settlement discussions and what was discussed. So there are some other terms here that are being presented. The respondent has continued to indicate he was unaware, he had a lot of things happening, he had agents. I want to remind the board that the respondent here, as the principal, he is responsible for the acts and or the failures of his agent. And so, again, through the record that we have, I think we've demonstrated that he had been made aware by his agent through the communication. Additionally, the respondent has spoken to this being unusual, cruel and unusual, and following out the current process. Staff at no point has made any indication of any pursuing of any criminal acts or any criminal prosecution. The argument regarding the excessive fine, staff has presented the fines and the recommended penalties here, considering all the factors that are listed in water code, and justify those as presented to you. The board has, in the past, entertained settlement amounts that are that are in the range, but also are significantly from what is presented to the board. In those situations, those cases primarily resulted in the lack of maintenance for permitted encroachments or a non-permitted encroachment that existed in the system. And in those, the penalty that the board assessed was significantly higher here, considering the type of encroachments that were presented at that time, compared to the permanent encroachments that are before you today through this case. And I will save the rest for the closing statement, if I'm allowed.
Yes, thank you. Do we have any questions from board members to the prosecution team? Board Member Countryman.
I want to ask the same question I asked the defendant here. Has the staff received the plans concerning the existing boat dock? And if so, does the dock meet board standards?
This is not, can you hear me? 1, 2, 3? Okay. Angeles Calisto. Yes, and I think the record in the staff report in the hearing, we included the copies of those plans that were submitted to staff. There were 2 submissions made to board staff, one in December, and then one was done later in February, I believe, with a response letter to both of those. The review of staff found that the boat dock appeared to comply with most of the applicable Title 23 sections, and the ones that remain were identified in Ms. Tu presentation.
I didn't quite get that last part. What's the part that wasn't in compliance?
I may need a moment to look back through the review of our plans, if that's okay. Okay, I've reviewed our February 12, 2028 meeting, which is part of the record. And in that, we determined that the sections that apply in Title 23 had been complied for the technical standards for the boat dock.
Okay. I mean, I'm asking this because it seems to be significant when we're talking about such large fines here. Was there an actual threat to the flood system, or is it just an administrative issue, which I feel have been way out of line, meeting the administrative requirements, but it wasn't a public safety issue as such. So that's why I'm asking that question. Concerning the fence, I look at the fence. I mean, I don't have the plans and everything here, but it seems to be see-through. It seems to meet the board standards. What, am I wrong there?
Angeles Calisto, board staff. I think what is at the essence of this case, Board Member Countryman, is what we presented back at the CDO meeting, which is really going back to a policy decision on how the board wants to evaluate and treat respondents or applicants who don't follow through and secure their permits in advance to allow the proper reviews to happen. Unfortunately, the enforcement section, but also other sections, the board continues to see unauthorized encroachments throughout the system on a regular basis. It's an everyday thing. My team hears that every time. You hear every month by the Army Corps of Engineers inspection reports that are presented to you where they consistently report encroachments being one of the factors for systems, continuing to lose PL 8499 eligibility. So I go back to the intent behind the board's authority and responsibility for flood control. Following the permitting process, respondents in many cases, applicants, what incentive do they have to follow through the process if there are no consequences in waiting? And unfortunately, we hear from the community, regulated community, it is known out there that our time frame and our permitting process is lengthy. And many of them choose to proceed because they are not willing to wait the 2+ years of review time frame, and instead elect to take a chance to see if they are caught during the enforcement, through an enforcement action.
Has the board ever received an application for a permit for the fence?
No, we do not. We don't have any record of the fence.
So that's still something that has not been complied with. Even if it meant board standards, no permit had been requested, is that right?
Correct.
Okay, thank you.
Thank you, Board Member Countryman. Board Member Grego?
Yeah, I just want to follow up on what the board member was talking about. So originally there was 24 violations, and then it's been worked down to 14. Is that correct? And is that part of? I know that when you look at penalties, you have a range that you can use, and so my understanding was the $800 and some odd was like to the very full max. Did reducing those penalties by 10? Did that have a reflection on the lower price of the penalties?
Angeles Calizo again. Yes, that's correct. That is why the administrative penalty that's before the board today, it is a significantly lower penalty than what was discussed initially with the respondent.
And so that's part of the reason why that penalty was reduced. And it wasn't just because you decided, it was because of the reduced amount of penalties that were being assessed. Is that correct?
Yes, that's correct. It reflected the 14 violations that were shown to be corrected by the respondent after the CDO.
Are the 14 penalties that still exist, are those able to be reconciled?
Angeles Calizo, let me correct the record. I said
the violations. I'm sorry. The 14 violations. Are they? How would you view them? Are they able to be mitigated? Yeah, mitigated or resolved.
Angeles Calizo here. I want to make a correction to my prior statement. I said 14 violations, but really there were 10 that were shown to be resolved, remaining, leaving
Correct.
14. Correct.
14, yes.
So for the 14 that remain, as you saw, and I think Ms. Tu highlighted, the majority of those relate to the failure to secure the board permit and the 8,700 citations. The one that remains with some applicable technical standards still is the retaining wall or the fence itself that is located on the waterside shoulder.
Very good. Thank you very much.
Board Member Bosler? Oh, Board Member Andrews. I saw you waving.
Thank you.
Thank you.
Thank you for that clarification. This is Board Member Andrews. It seems to me that that essentially there are a number of violations that cannot be corrected because they relate to the failure to submit the permit. You just clarified what remained. We have the fence and the shade structure that were never part of any permit process, haven't been reviewed. We have the problem of the pilings that were left in the channel during construction. And we have the fact that a lot of things may meet technical standards, but they were not included in a permit that was submitted in a timely fashion. And so is it correct to think of the penalties that you have proposed as other than the things, the pilings, the fence, the shade structure, the old pilings remaining, that is, everything else reflects a penalty associated with the failure to have submitted a permit in the first place? Is that an appropriate way to think about what is proposed as a penalty?
Yes, and I would refer back to the water code, a statute that requires the factors that are to be considered as part of the penalty.
Thank you.
Board Member Grego.
One of the things that's been brought up and that really has an effect on me is the fact that the PL 8499, that's really important. And I'm not even sure if you understand what that is, but it's an important insurance product for everybody who lives along that levee area. And those inspections that come not only from us, but from the Army Corps of Engineers, when there are these types of violation, you put the whole section of levees and all those that live there at risk in regards to if there was a levee failure, who would pay for that? And to me, this, it's been brought up in our staff report that this is a potential problem here. And I just don't want to lose fact that this is really an important element brought up in this hearing, is that there's the possibility for that insurance product to be taken away from everybody who lives along that levee section because of this violation.
Thank you. And Board Member Bosler has been in my blind spot as I drive this car all day. So
Board Member Griego stole my thunder. So no, I just wanted to ask though the board staff, the communications from the Army Corps of Engineer, which are in the packet, seem to convey that they know about this unpermitted structure. They know that that's our job to permit these structures, and they know that this is not in compliance. Again, just like what are the steps? What are the processes that we need to do to be able to remedy this, like with the focus on ensuring the safety of the structure, which I want to second what Board Member Griego said just about the very significant hundreds of millions of dollars, tens of millions of dollars in some cases, but hundreds of millions in other cases of resources that are coming to the state, to locals, to repair levees if there's a failure, and how that would be impacted. So I'm very, very focused and concerned about the compliance issue that we have with the Army Corps of Engineers and how we can move to that.
thank you. Other questions from board members? I don't have a question, but I do have a couple things I am just going to note before we go to public comment. One is I just checked, and in removal of the unauthorized encroachments identified in the CDO is part of the staff recommendation. I was going back to check and confirm that. The second thing is we had a couple of different characterizations of the action that the board took at our September meeting, and I'm gonna read this so that it's fresh in everybody's mind, so that we don't have to rely on anybody's characterization of what it was. The proposed motion is to affirm the cease and desist order for case number 2025-15719. Staff are also directed to negotiate a resolution with respondent. A satisfactory resolution will include a path for the encroachments identified in the cease and desist order to be permitted, This action only applies to encroachments that are identified in the cease and desist order. It would not apply to other unpermitted encroachments that may exist on the property. As to the encroachments that are within the cease and desist order, a permitting decision has not been made and modifications may be required to meet Water Code and Title 23 requirements. This agreement must also include penalties in accordance with Water Code Section 8701.4 that address the staff time spent bringing this matter and to disincentivize future noncompliance from the respondent in the greater regulated community. And it goes on to set a schedule, including reporting back at the October meeting if there's not an agreement.
Do we get an opportunity to respond before public comment to what they said in rebuttal?
We're going to do public comment, and then you each get 5 more minutes to close.
Okay.
And with that, we'll go to the public comment if we have any. We'll start here in the room first. Anybody who would like to address the board from the podium? And online?
No hands raised online.
Okay, so there was no public comment. And so now you have your 5 minutes to respond to anything you want and wrap up, and then we'll go back to the prosecution for theirs.
Oh, sorry. Yes, John Garner, here with Padre Terrafard. To respond to what you just stated, and counsel for the board got up and said there's been no due process violations. No, first off, we don't just take that at face value. What we're saying is, and I guess I appreciate Secretary Johnson, you reading that into the record, is that by tethering the two, you collapse the process, and that is the due process violation. The board has power to penalize or not. The staff can make a recommendation about what the power should be. To the extent that there's concern about insurance, he wants to permit the dock. There was a recognition at the last meeting he can permit the dock. His ability to permit the dock has been held by staff unless he agrees to the penalty. You're marrying the two things. In marrying the two things, you're delegating your penalty power to staff. Staff started out at $840,000. And Ms. Griego had a great question. The problem is the record doesn't support at all what staff's response was. They were at $200,000 in terms of a penalty offer to my client, Mr. Terrafard, before they reduced it to 14 violations. Their response at that moment was completely nonsensical, and that's precisely why they can make a recommendation and a report to the board about what a penalty should be and what makes up the penalty. The board has the power to penalize. And so we really want to tease that out. At the last board meeting, this board made a determination that he could go permit it. If the board's position here today, and like I said, I mean, obviously this may very well just be the beginning of a longer fight. If the board's position here today is that, yeah, well, we said he could permit it provided that he paid staff enough money, I mean, that's really what, you know, if I'm interpreting what was just read into the record, that's what we're trying to avoid here today, is just separate the two things. That's it. And if we're worried about the safety of people on the levee, if we're worried about insurance, and we recognize that people, I mean, anybody, even billionaires to some extent, have finite resource, then wouldn't this board want all resource to be devoted immediately to the permitting process? Mr. Wright's sitting here. He's the engineer. He's got the documentation. He hasn't spoken to any of this today. They had a chance to present evidence. There's no issue with the plans he submitted. To Mr. Countryman's questions, he did exactly what he was asked to do of this board after the last meeting. He submitted the plans. The plans indicated everything met specs. The undisputed evidence here before the board has been that this all went off the tracks because there was a dispute over money. He didn't have he can't make the staff approve something. If the staff's saying, look, to go forward though, and for us to submit this to the board as a proposed order, you got to agree to the money amount, that is the due process violation. That is them usurping the penalty power of this board. You have to separate the two. And so I appreciate it being read into the record because probably one of the things we want to make most clear on the record. And also in the record, and just making sure the record's clear on this as well, that no, there's absolutely no tether between the penalty being proposed today and the number of penalties today versus the number of penalties in October. I appreciate the board staff said that, because a very simple mathematical equation will show that that's untrue subsequent to this hearing. And like I said, I mean, this is, you know, if it's unfortunate if this board does anything today beyond just ordering that he go finish the permit process. We can come back and discuss penalties, but you can't delegate that away. You can't delegate your police power. That's why we have cops, judges, DAs. They all have different roles. You guys have a role. You can't give away that role to the staff. That's why we get $840,000 demands. They're not the ones that make those determinations. They're the cops here. They're the prosecutors here. You guys are the judge and the jury. And so it's just completely unjust to tie those two together. If that's, you know, again, you were just reading what the notes said or what was taken away from it. If that was the board's intent, was to delegate it, then the board did do something wrong, and we'll handle that accordingly. If the staff married the two things and usurped the board's penalty power, then staff did something wrong. But either way, that's your power, and it has to come back before the board, and there has to be a hearing, and the penalty has to be based on facts and evidence. It's not what we have here, because the evidence is skewed because my client wasn't able to comply because the two things were married in the first place. That's the due process violation that we're talking about. And counsel's simple statement in the alternative is noted, but frankly is of no practical consequence. It's just her opinion. So with that, it will end. We just are asking the board, do the right thing and let this gentleman permit this project, and then come back, and then we'll determine if there's a penalty. There would be no benefit in issuing a penalty today, because all it's going to do is deprive him of the ability to focus on what should be everybody's chief concern, which is get it permitted. And if it can't get permitted, then we want to know that. And experts should come here and talk to you guys. Mr. Wright should do more talking and less board staff. And the engineers should be talking about what is safe or not safe, not board staff and me. And then we can have a hearing on whether or not the permitting should be done. And then when that's all done, we can evaluate whether Mr. Terrifard did anything wrong or not. And then we come back on penalty. You can't do them at the same time. And with that, respectfully, we thank the board for your time. And you know, Mr. Terrifard just wants to be a good steward of the land.
Thank you. I believe our board counsel wants to interject here.
Thank you, Secretary Johnson, Board Counsel Jeet Dua. Just want to remind the board and for those here that staff does not have settlement authority. They can recommend a settlement to the board. All settlements are brought back to the board for approval, and that was expected here as well.
I'd like to respond to that. I don't even know why that comment was offered at this point in time, other than to confuse. Because is he speaking for the staff now, or is he speaking for the board? Or what bearing did it have on this proceeding?
Explain how the teams are set up, Jeet.
I'm sorry.
The roles for you relative to the prosecution team.
Yeah.
That may clarify.
Yeah. Thank you. My role is to advise the board, so I'm reminding the board that all settlement offers are brought back to the board for their approval.
And I'd just like to respond briefly to that, to the extent he's characterized. Well, then I'd like the record to reflect that we object to the statement to the extent that it characterizes that as having been what occurred here today. It's undisputed that what occurred here today was they tethered the two things together in terms of letting him go forward. That goes exactly to what Mr. Countryman was asking about.
We're good. I understand what you're saying.
Thank you.
Thank you. Back to the prosecution for their final comments here, and we'll give you 6 minutes since that's what we took on the other side.
One, two, three. Thank you. This is Jennifer Scheck with DWR once again. I would like to respond to the due process. As Jeet Dua already explained to the board, there is no settlement authority by the staff. That has to be a proposal to the board that the board then hears at a meeting and decides whether or not to accept. This is why all previous documents between staff and respondent and their counsels said proposed order, proposed settlement, because it was made clear that the board would have to agree on it. No delegation of authority was made. Regarding the resources, Mr. Terraford has repeatedly stated that he has a defense of inability to pay, and he has been repeatedly invited, including at the board meeting in September of 2025, to produce any records to support his defense. And then finally, as far as whether or not the encroachments met the specifications, it's not clear because it did not go through a permit review process, including the 408 process by the Army Corps of Engineers. It's a 2-year process because so many engineers and departments have to review it. And then the permit application has a set of waivers, 18 to 24 I've seen on these permits, that waive liability, et cetera, that discuss the construction. None of those documentations were done because there was no permit. I don't think I have anything else to address, in which case, if there are no questions, I'll leave it to Ms. Calizo. Thank you.
Angeles Calizo again, Board Enforcement Section Manager. I will provide a closing statement here for the prosecution. So established in the hearing documents for this case, the property remains subject to the board's regulatory authority. The record shows that the respondent constructed and began the work without securing the permit, and he also deviated significantly from the original application. He additionally constructed additional encroachments that were not part of that application process, and then included the secondary structure that he failed to disclose when he addressed the board at the September 26, 2025 CDO meeting. The respondent has characterized the unpermitted work as an administrative error, but the encroachments involve significant structural modifications to the levee and to the channel. These encroachments and these modifications impede maintenance, access, and essential flood control functions and jeopardize the eligibility for the entire flood control system under the PL 8499 program. The respondent behavior undermines the board's regulatory and enforcement authority, increasing flood risk to the community at large. The respondent could have avoided all this penalty by first securing his permit or engaging with the staff through the settlement negotiations that have been discussed, or complying with the CDO. Settlement negotiations ended not due to staff's penalty amount, but it was to the respondent's insistence of continuing to use the boat dock while it remained unpermitted. The penalties that were presented to the board were significantly less than what is authorized by the code. I wanted, for context, provide the board with enforcement actions that have assessed larger penalties for infractions that are much less, arguably much less, than the case that is here before you today. An enforcement case in 2020 considered a penalty, and the board affirmed a penalty of $106,000, and that was for improper maintenance of an encroachment. That not only required the respondent to correct the violations, but also impose a penalty amount. In 2021, the board also assessed a penalty of $42,500 for non-compliant irrigation facilities that again require the respondent to bring those facilities into compliance at his cost and pay the penalty. In 2022, the board affirmed the board was scheduled to consider a penalty of $75,000, and this is for non-permitted encroachments on the waterside berm. This included bamboo pots. The stipulated order that was then considered by the board, that was negotiated by staff as part of that case, came to the board for approval. And that penalty included $25,000 with $25,000 that were deferred for a 2-year compliance period by the respondent. Again, in all of these cases, the board's lowest penalty was $42,000 and for lack of maintenance of permitted encroachments or non-permitted encroachments. Board staff has detailed the rationale that is requesting the penalty. We assert that the penalties combined with the directive for the removal of the unlawful encroachments and restoring of the safe flood control facilities are fair and proportionate. Although they are monetarily well below the maximum legal maximums, this proposed order achieves the board's core objectives of compliance, deterrence, and public safety. And the staff respectfully recommends that the board adopt the proposed enforcement order. Thank you.
Thank you. Now I'll check with board counsel to confirm that I believe that we closed the evidentiary part of the hearing here and go back to the board for discussion on a possible motion. I'll check really quickly to see if any board members have factual questions before we go to the discussion. Board Member Countryman.
I don't think this is the case, but I haven't heard it said. The defendants are saying you would not process the permit for the dock because you couldn't come to an agreement on the fine. If that's the case, I have a problem with that. What is keeping the board at this time from processing the application for the dock? Let's take the dock. Do you have everything you need to process an application for the dock?
Angeles Calizo. At this time, there is no formal application submitted for the encroachments or the boat dock. The application that was submitted by the respondent in 2023 was for a prior dock, and that was never completed. The current encroachment in question as part of this order is significantly different from what was there, so a new application would have to be required and submitted. I would want to characterize the direction from the board was that the opportunity to permit the encroachments was going to be part of the settlement discussions with staff. And so we made clear to the respondent that he could secure and he could pursue a permit application, but there were terms that were part of the presentation and the settlement discussions that were included as well.
But did staff at any time indicate I understand a new permit application was necessary. It makes sense because it's different and so forth. But that could not be processed unless there was an agreement on what the fine was?
What we discussed with the respondent is that before we initiate a permit application for the dock and the other encroachments, that there was agreement to the terms of the entire case. And so one of the terms was penalties. There was other terms that were included about compliance period as well to ensure future compliance. We also discussed a inspection of the site to make sure that his application would be comprehensive and address additional potential encroachments not already identified in the board's enforcement action, where it would benefit him to include those as part of one submittal. So our recommendation and the discussions were that the submission should be comprehensive so that it would cover all board permitting items and encroachments on the property with one submission.
Do we have an easement over that property? Why do we need permission to go and inspect it?
That was one of the, Angeles Calizo again. We do have an easement. There is an easement that is shared with the Reclamation District. During the staff had discussed doing a site inspection to make identification of potential additional encroachments. To date, the respondent has not granted that opportunity for staff to access or do that inspection.
Well, I guess I'm confused. Why does he have to grant anything? You have an easement. Why can't you go and look at it?
Good morning again. This is Jennifer Scheck. Mr. Terraford has Fourth Amendment rights on his private property and home. So although we have an easement, he has to give us permission to go onto his property.
Just objecting for the record. She's an attorney. It's an opinion. We want to state, just for the record, that that's not an accurate statement of the law. But they're making a record. We got to have a record.
Board Member Grego.
Yeah, just to kind of clear up some of the comments that Countryman just made. So when you were sitting down with the property owner, was there any indication that in order to do the permitting process, you're going to have to pay this amount? I mean, and let me just say this. this is not their first rodeo. It may be your first rodeo, but it's certainly not theirs. And you've heard that they've had penalties. We've had these cases before. But I'm going to ask them the question because I want it to be on the record. Was there any insinuations that he had to pay before he was able to start that permitting process?
Angeles Calizo again. The settlement discussions included several terms. One of them was an administrative penalty, which I believe the respondent has spoken about. There were other terms that were part of that discussion that were not discussed here, but the submission of an application was not held hostage, as the respondent has indicated here. It was going to be one of the terms, and once all the terms that were part of that discussion were agreed upon, then the matter would come to the board for consideration.
Okay. Yeah, I just wanted to put that on the record because I know that our staff is, very competent when they are taking these cases on, and the record's very important, especially if it pursues further. Thank you.
A question. Does he need your permission to submit an application?
The direction from the board at the CDO was that the closure of the enforcement case. So the CDO, he doesn't need permission from board staff in particular. The direction from the board was to negotiate an agreement that included the opportunity to permit.
Final questions before we turn back to the board for discussion and a possible motion? Seeing none. Oh, we do.
All right, just one thing that has perplexed me. We have heard a lot of different descriptions batted around about settlement offers by one side and the other side that are completely at odds. I trust there is a written record of at least offers made from each side that would corroborate what we are hearing from our staff.
Angeles Calizo, yes, that's correct. That communication was not included because, again, the settlement discussions were intended to be confidential.
Certainly. It is my recollection and consistent with what was read into the record by Secretary Johnson that the board did direct that penalties be included that would act as a deterrent to others who may want to follow suit and simply build first and ask forgiveness later. That was distinctly not behavior we wanted to encourage, and so I do believe that staff was specifically directed to make that part of the settlement discussion with proper name, respondent. And can our prosecution staff corroborate that statement, that was your understanding of the direction given to you by the board as well?
Angeles Calizo, yes, that's correct.
One more time. Questions? Okay. With that, we'll close the testimony part of this hearing, and we'll thank you all for being here. I think you can sit back in the audience if you like, and then we'll bring it back to the board for discussion. Who wants to open it up?
I'll open it up.
Board Member Countryman.
I feel that the defendant has acted improperly. We're 3 years and we don't have an approved permit. There have been multiple chances contacting both his attorneys and representatives as well as himself. I think that's indisputable, and I'm sad about it. I'm sad it's caused so much grief to you personally, because it just seems totally unnecessary. But thinking about the what we're talking about. And when I ask my questions, I don't think that these encroachments represent a threat to the levee. I don't believe the dock does, and I don't believe the fence does. So if I felt that there was any direct threat to the levee, I would be for very severe penalties. But I think in a way, even though I don't want to say it, there does seem to be an administrative issue here of the defendant not being non-compliant. And I really am distressed to find that possibly he rightfully gained the impression that we wouldn't process his permit if we didn't agree to a penalty of several $100,000. To me, that is outrageous. And I feel that I'm looking at the penalties here. Staff time was $30,000. I think an appropriate penalty would be $50,000 at the maximum. I don't know how we do that and gain compliance with him getting the two permits that he needs, a permit for the dock and a permit for the fence. But if we could assure that we could get those permits, I think $50,000 is certainly a big incentive to any homeowner to never do that again. It sends a message clearly that don't ever do that for any of his neighbors. So that's what my recommendation is that we limit the penalty to $50,000. And I don't know, can we condition this that the permitting for the dock and for the fence is completed?
I think that's probably a question for board counsel. Joe, you're asking a question about how, I believe that's a question for staff. Say it again, Joe, the question.
Well, number one, my thought is that we limit the penalty to $50,000. But I want to condition that we get action, that we get a properly submitted permit for the dock and a properly permitted set for the fence. So we can review those, and just from my inspection, I'm pretty sure the fence is going to pass. And it seems like the dock, from what was said, is going to pass. So we no longer have the problem of unpermitted features in the floodway, and then a proper penalty for the build first and get permission later of $50,000 seems to me to be reasonable. So I don't know how to put that in a motion, but that's what I'd like to acquire.
Okay, so maybe there's not a question for at the moment. We'll continue the discussion, and then we'll come back if that makes sense. Board Member Griego?
Yes, through the chair, if we can hold any motions until we have discussed all of this, and then we'll go.
I agree.
Go forward with that. Sorry. You know, I feel a lot like Countryman does in regards to the property owner. You know, it was in last year when we had this discussion, I think we were all feeling very sympathetic towards the process, and that's why we directed him to go and do this negotiation with our staff. I understand that not everybody understands the government process. I mean, most of us just don't. We could be good business owners and still not understand the government process. So I think we gave some clarification about what we wanted to achieve. And I know that the property owner has never had a problem coming to this board and talking to us. And that's my concern, is that you never came back to talk to us. You know, we were all wondering, where was this at? And it was on our staff's hand, and we delegated them to do that. But you could have always come to this board and voiced your opinions in regards to how you were reacting towards the negotiations. The other problem I guess I have is, the original permit did not include all of didn't complete all of the project. It was not, it expanded beyond the permit initially that was brought to this board. And so there, again, it gives me some heartburn about this process. I think it's a beautiful boat, project that you did. I'm sure that the engineering probably was acceptable. It was the fact that there was just not that follow-through in regards to seeing this completed. Now, I believe that there should be an assessment for penalties. I think it should be higher than what Joe has, represented in order to be the deterrent. And that's the biggest thing right now. We just don't want everybody saying, oh, well, we can put that project out there, ask for forgiveness. They give us a $50,000 penalty, but we just improved our property values by $500,000. I mean, some people would think that. I'm not saying you do. I'm just saying some people would think that. And so there has to be some deterrent here in order to make sure that this doesn't come before our board again. I think this experience has been a learning lesson for not just the board and not for the landowner, but for our staff as well. If the project is being done adequately, but we want to see those permits done as well. So I guess I'll stop right there with my thoughts.
Thank you. Board Member Grego. Board Member Andrews.
I believe that one of the questions that Member Countryman had when he was speaking was whether it would be possible to revisit the penalties should the permit application not be submitted, a complete permit application, so that there was follow through. Can I confirm that in the event that those unpermitted structures remained, that we could revisit the penalties and assess additional penalties if the boat dock remained because a complete application had not been submitted, had not gone through the process, and a permit been given? Would we be limited to some sort of, well, we penalized you once, we can't penalize you again for the same problem? Is that clear enough, Mr. Dua?
I believe so. So the question is, can you issue an order of penalty today and then issue a subsequent penalty later? And I think it would depend on the motion. So you could certainly assess penalties for what you believe is appropriate today, or as counsel for respondent has said, and hold in abeyance. You can hold them all in abeyance and decide them all later to make it cleaner if you're going in that direction, or you could assess them today, and then if it has to come back because the process is not completed, the permit application isn't submitted, reviewed, approved by both board staff and the Corps, because staff cannot, or the board cannot issue a permit until the Corps has signed off on it. Mm-hmm. And if that doesn't happen, obviously, I think, the potential is there for additional enforcement activities to take to occur with respect to this matter.
Thank you.
I hope that's helpful.
Yes, very helpful. Thank you.
I should just clarify. Now, whether or not you would tie those penalties to the previous or just a subsequent activity, that's what the board would be looking at, not what had happened here today, but what happens after for any additional penalties.
Okay. I want the defendant to recognize the incredible responsibility that this board holds to protect life and property with the flood system. And every person who owns land, engages in activities within that flood system has the potential to negatively affect that flood risk reduction function. And that is why we take this so seriously. It is not out of a great desire for retribution for someone who does not follow government procedures. It is, I'm sure it feels that way sometimes, but the actions that our staff takes and that we take today are founded in that very important responsibility that we as a board have to the people who are being protected and whose assets are being protected within the adopted plan of flood control. And I have no further questions. Thank you.
Thank you.
I still have some like tactical and like maybe specific questions about, I mean, because the order today is for the property owner to remove all permitted and pay the penalty. So nothing in that like is a path to permit besides like starting over. Is that, I guess I'm just struggling with this.
Just want to show the record. It was Board Member Bosler asking the question. Board Counsel Dua. That is the proposed order. So it is just a proposal before the board for its consideration. The board can amend the proposal, the order. It can reject the order. It can come up with its own order, just like it did at the CDO, where it instructed staff to try to resolve this by way of settlement. So the board has the discretion to either approve this order or come up with its own alternative.
Thank you. Board Member Grego.
I just want to say to the property owner, it sounds like this board would like to give you some consideration like they did last time. You know, but with that being said, I want to say something else, and I think the board stands behind this, is that our staff did a great job. And I know there was a lot of comments that were that didn't state that, but as this board member, I want to say that our board member did exactly what we asked them to do, and they complied with everything that we presented. I think the failure is your lack of understanding about government process. And if it wouldn't have been that, you would have had that permit, and we wouldn't be here today. And it would probably have been the least expensive thing of your project would have been that permit process. It's a timely process, and if this board gives you consideration, again, it's a timely process because we also have to depend on our partners, which is the Army Corps of Engineers and the 408 process. That's not a speedy process. This is a long-term process. And so that I hope that if this board reconsiders some consideration for the property owner, that we put some fines up front and put some penalties on the backside of it so that we get compliance in this. And I'm just throwing this out as a possibility because we need to make sure that there's follow-through in this time. This is the second time. If you decide to consider that, this is the second time we're giving in consideration, and we have to be stern on that. So I'm just putting it out there. I think it needs to be said, it needs to be on the record, that if this is something you're going to consider.
Thank you. I have a couple comments, and I'll come back over to Board Member Countryman. So I'm still weighing for myself what I think the appropriate fine would be. I'll say that I did look at the violations in the water code, and I believe that the staff recommendations are all justified. Doesn't follow that I necessarily think that they're the right outcome, and you know, because we don't delegate this and it's our responsibility, you know, we have to make a decision. And what Board Member Countryman and others have said, you know, carry a lot of weight with me. I I will say that of the three things that Mr. Terrifard could spend money on, pursuing a permit, paying a fine, removing the dock, the last one is the one that I would have him spend money on the least. I think the fine matters as deterrent to other people, and it's something that's noticeable. The cost of removal would be too, but it's not as obvious. The permits obviously are important to all of us. So that's what I'm thinking about here. It's hard because I can easily see myself in your situation. As Board Member Grego said, it's hard to know always what's required. And so, we really are trying to do the right thing here. I'll also say that from staff's point of view, I need to set my emotions aside a little bit as I listen to you talk about it, because I know they're doing the best they can with their jobs and trying to be good public servants. And whether it feels that way to you or not, I believe it to be true. And so to the extent you're blaming us for giving them bad direction, that's fine. We'll own that, whenever we do. So that's where I'm at. Board Member Countryman?
I just wanted to, in our package that we received, there's a question, what if board wants a different decision? If the board action is substantially different than that recommended in the staff report, the board may direct the staff to return at a subsequent board meeting with a revised resolution and/or proposed revised written conclusions that reflect the board action. Revised written conclusions may be placed on the consent calendar and do not reopen a hearing. Public comment is restricted to whether the revised written conclusions reflect the action of the board. So I think we could give direction at this point as to the requirement of the submittal of a complete application and decide on what the fine should be, and it could come back and be approved at the under the consent calendar at a future time.
Okay. I'm going to run this by our board counsel. My understanding, and certainly my recommendation, is that the board be very clear in the motion what the decision is, and that this meeting be the decision meeting. And the thing that's coming back is the finding of facts and the writing it up to confirm that we got it right. Otherwise, the other choice, which we could also do, is we write it all out the way we did last time,
right,
and do it that way.
Should be clear.
So I agree. I think that's the right procedure, Board Member Countryman, and also that we should be very clear about what the actual outcome is. Board Member Andrews.
I think we're all very supportive of the homeowner being able to get a permit submitted, get his project permitted, assuming that it can be modified as needed to do so, and that it can go through the 408 process. I feel like for us to have a decision that includes both a penalty and submittal of that complete permit package, permit application package, there needs to be a timeline for compliance. That there be some period of time specified within which that complete permit package must be assembled. And I assume there's also some sort of time associated with payment of the penalty that could be stated, or we could just leave that to the processes that are available to us to collect. But in terms of the submittal of the complete permit package, I'd like to get some advice on what would be a reasonable time period to specify for that. I suppose that's a question for you, Angeles.
Thank you, Board Member Andrews. I wasn't sure if you were speaking to Board. Angeles Calizo, Board Enforcement Section Manager. Regarding the, I think Water Code specifies that any assessment of penalties that the board makes a decision on are due within 60 days of the board's decision. So that would speak to the your first question. The other one regarding timeline and completions, I believe the respondent, I think, has a decent package for some of the elements of the encroachments in question. So I think either a 60-day or 90-day timeframe for submission of a completed application, it seems reasonable.
Thank you. Board Member Grego.
Just following up on that question, can you give us an idea about the process of getting that application completed into this board, considering that it would have to go through the Army Corps of Engineers? What's that look like? I want him to hear this.
It comes to us first.
Does it come to us first?
Angeles Calizo here. So the process that currently is in place for the permitting, so when an application is submitted to the board, and typically would go to the permitting section, they would do an initial review and assessment of that application within a specified timeframe. Then they will complete a technical review, typically within 60 days. At that point, then the application gets, if it's complete and the elements of technical compliance seem to have been met, then that submission then gets sent over to the Army Corps of Engineers Section 408 for review. And then at that point, that begins the 408 process. And so in that process, there may be some back and forth. There may be some requests for information from the Corps through their different consultations that they are to do as part of that review process. That will, once that's all complete, typically 18 to 24 months, then that will culminate in what we refer to as a 408, Section 408 Letter of Permission, LOP. And then at that point, the matter will come back to the board, the permit, for approval either as consent or either through our delegated authority.
Thank you. That's helpful. More board members who want to make suggestions, and or a motion at this point. I think
I'll make a suggestion.
if you want to keep discussing it, make the suggestions first. Maybe make the suggestions and talk about it, and then we'll package it into a motion if we come to. That's how I would do it.
I think at this point, I think we should allow 90 days for submission of a complete application. In other words, our staff has completed it, has received it, reviewed it, and it's complete. So after that, it's sent to the Corps. So we have no control, or nor does the defendant have any control after that point. So I would say that this is subject to a complete application, permit application for the fence and for the dock within 90 days, and a proposed fine of $50,000.
Board Member Grego.
So I guess in regards to what you had just said, Joe, is that $50,000 up front for the fine, but if it doesn't happen, not due to process, but because the applicant just doesn't follow through on that, is there a penalty that is associated? Is that something that the board would do, is a penalty associated, or legally can we do that?
Board Counsel, you can suspend penalties, as the board has done that in the past, and Ms. Calizo testified to at least one instance where...
We did. I remember that one.
Yes.
And so I guess, my concern for even asking that is because we didn't have follow-through the first time, and I want to incentivize follow-through. So if you follow through, then there is no penalty at the end of it. There's not an additional penalty at the end of it.
Right.
If you don't follow through, there's going to be an assessed penalty on your part, not on the process with the Corps of Engineers or this board, but if you don't follow through with, what's been required to accomplish, then there will be a penalty that would be after the fact.
In addition, yeah.
Yeah, in addition to the first penalty.
I have no desire not to follow through. I've always followed through with everything I've ever done. And in this case, the staff has held me up for 9 months. I had no intention of not submitting, but I asked to come back to this board. I came and spoke over here for 3 minutes a few months ago, and I asked multiple times to just be in front of the board and get this over with. I did not want this process dragged out. I tried, I did everything that I could, and I will continue to do everything that I can in my power. I will get you that in 90 days. I'll get it to you in 60 days. I might even get it to you in 30 days. But if I'm being held up on this end, I have no control over that, and I don't know the bureaucratic process. Right. So that's that.
Thank you. We have several mics on. I'm going to go to Board Counsel Jeet Dua first and ask Joe to turn his mic off.
Thank you. I just wanted to get back to Joe's earlier question about once it's within the Corps, there's no control, and it's complete and it's out of board staff's hands. Just wanted to remind the board that once the application is submitted to the Corps also does its own review, and they may notice things that are incomplete and need further information, and then that will get transmitted back to the board, which will then be transmitted to the applicant. So there may be some back and forth, some additional information needed from the Corps for them to do their review, even though staff has deemed the application complete.
Thank you. I have a question for the two of you who are making suggestions. And feel free to think about it or tell me you don't know the answer. But to Board Member Griego, what the fine would be if the application isn't submitted, the additional fine, excuse me. And to both of you, whether this package continues to include the removal of the encroachments, or the direction is to take that out and allow the encroachment to remain while this is playing out.
Well, that's my intention. That it is allowed to remain while this is being processed.
Thank you. Board Member Griego.
What I heard today, and I guess I may need some clarification about this, is that the engineering part was acceptable. That's what I heard today. And so if it's acceptable, then I don't see a reason why it needs to be removed. It was all based around the, what I heard was that it was, these violations were based around the lack of a permit.
Board Member Bosler.
I have a suggestion. So kind of a three-part. So we've got the permit, we've got a penalty. I'm undecided about the right amount, but there's been a suggestion. And then the third thing would be if either of those things are not done, there would be a proceeding to remove the structures.
Through the chair.
Board Member Griego.
So a motion could include to proceed forward with them, allowing them to do the permit process with a $50,000 penalty, and that at the end of the process, if there's no follow-through on this, that there would be a penalty of a certain amount, and that the boat dock would have to be removed. Is that what I'm hearing? Is part of the, could be part of the motion?
Well, and just to be clear, to remove the boat dock and all of the unpermitted structures would be hundreds of thousands of dollars on the landowner to remove, right? Like, I mean, it would be on them.
Through the chair, Mary Jane Griego. So that would be in lieu of a penalty. Is that what you're stating? Is that the boat dock would be removed in lieu?
I mean, I think there's a decision point there about whether to add a penalty to the removal. Like that would be in addition to the hundreds of thousands the landowner would have to pay to remove the unpermitted structures.
I see. I'm just trying to formulate some kind of motion here so that we can come to a conclusion.
It seems to me, excuse me, Board Member Andrews, it seems to me that we could structure the motion to include the initial penalty, the submittal of a permit package deemed complete by our staff within a certain time period, and have some criteria by which lack of follow-through would warrant the order for boat dock removal, all the structures removal without need for an additional penalty. What I'm not sure about is what those criteria would be. Is it failure to receive the 408 LOP, failure to get that final permit from the board? I mean, they seem like the same thing to me. And at that point, you have an unpermitted structure, and it shouldn't be a problem then to move on to a standard, removal of the unpermitted structure language. So it seems to me that with those pieces, we could have a motion. I'm just not sure what the language needs to be exactly. But I think if we all agree on that sort of structure, that's something that can be sorted out. And then we're just left with the thorny issue of what is the right amount of upfront penalty.
That sounds right to me. Board Member Grego.
So maybe we could take maybe a 10-minute break and consult with our attorney for the wording so that we come up with something, a motion that addresses all the issues that the board members have addressed.
I think we need to do the substance, here in front of everybody. Personally, I think we could give direction as to what to write, and then maybe do it with one of us and both people watching. It wouldn't be. I'm not asking for like a negotiated handoff, but just a transparent process for me getting the direction from the board. I also think we could do a motion that captures it and talk about it and look over here to make sure that's true. Let's try to pin down what the substance of it is first, and then we can ask guidance as to the best way to record it.
Yeah, and my intentions were always to be transparent. It was just trying to get everything captured into the motion. So
I'll try. Okay. First, the defendants will provide complete applications for the boat dock and for the fence within 90 days. Of course, to be sure it's complete, it'd be a lot better if you could get it in 45 days so the staff could determine it's complete. But so 90 days to provide a complete applications for the fence and the boat dock. And secondly, the fine is currently $50,000. And if we don't get a complete application for the boat dock and the fence, we'll have another hearing to consider additional penalties.
I want to check to make sure that that's, it seems like an allowable motion to me, but I want to check with board council to make sure that if we do that, that it's procedurally proper and something that functions with the way the board operates.
It does. Board council do it. I would just, if I may make a suggestion, a complete application should be for all unpermitted encroachments instead of just the boat dock. There's also a conduit. There might be other things out there. I don't know. We could clarify with staff, but it should be a complete application for all unpermitted encroachments.
I agree. Board Member Grego.
Could we allow that our staff's allowed to go on the property for inspections? I mean, is that part of it, or is that just assumed?
I wouldn't assume anything. It makes sense to me if it makes sense to you.
Board council. There is, we do have an inspection process, but that typically takes place after the permit is issued before construction. So that would have to be part of the order if staff is going to be allowed to inspect the property or the proposed encroachments.
Construction's already complete.
Yeah. Well, at least a survey to determine all encroachments that need to be permitted is, I think, important.
Through the chair, this is Mary Jane, I just don't want that to be a barrier, and so that's why I bring it up.
Understood. Anybody else? Are you ready for a motion? I am.
Through the chair, was that your motion?
I restate it.
The three things would be the elements of the motion. I don't know how to put it together.
I'll go ahead, give it a shot.
Thank you.
Okay, I'd like to make a motion that we allow the landowner to submit a complete application, that in that complete application, that no barriers would be presented to our staff in regards to going on the property for inspection. At the end of that process, 90-day process, if that follow-through is not seen or accomplished, that this item would come back before the board with penalties and removal of the boat ramp, and that a $50,000 assessment would be also on the front end of the penalties. God, does that sound right? Did I do that right?
Well, you make it sound like it's...
Yeah, part of the penalty, yeah. So one of the flavors of this ingredient is that there is a $50,000 penalty in association with submitting a application for a permit.
Board Member Andrews.
Just a recommendation to modify that it not be associated with the permit submittal, because I think that penalty needs to be levied regardless of whether the action is taken on the permit submittal. We have a different recourse for additional penalties if it is not.
Yeah, I'm sorry, I should have stated that up front on the motion. Do you want me to go ahead and read?
Yeah, let's do it again.
Okay. I'm going to make a motion that we assess a $50,000 penalty, that the property owner has 90 days to submit a complete application on all encroachments on the property, and that if it fails to be completed within that period of time, that it will be brought back to this board for consideration of removal. Did I catch it all?
That sounds right to me. Our board counsel is nodding.
I would just add again, board counsel, unpermitted encroachments.
Unpermitted encroachments.
Unpermitted encroachments.
Yeah, there's a correction on that, and that we have access to the property for inspection.
And is this something that we're doing finally now? As I'm asking for guidance, or if we're making the decision based on this motion, but then the findings of fact and things come back, just need to be cleaned up and documented in writing.
That is correct. The prosecution's counsel would be presenting that.
Right.
For-
But the decision
for-
is made today, and
decision
the
is-
paperwork comes back on consent reflecting the decision.
That is correct.
Okay. Board Member Andrews.
Just another issue that may lead to refinement. Can I confirm that if 18 months, 2 years, 2.5 years have gone by and there is no 408 and no final permit issued, that we have recourse under standard board procedures to take action and require something else, or do we need to build that in here too?
.408 for a boat dock is pretty cut and dried. I mean, I think they even have a speeded up process for those, I believe. So I don't see that's a problem. When we say it's a complete package, it's going to meet the 408 requirement, I believe. But the property owner has no control over the Corps of Engineers, so.
In recognition of the fact that we are allowing this unpermitted structure to remain in place during this whole period, I just want to make sure that at some point in the process, if it does not become permitted, that we have some recourse at that time. And do we need to build that into the current motion, or is that something that we can simply say, gosh, if it's still an unpermitted structure in, at a certain point, that we can come back and take action then?
To Board Counsel. Yeah, certainly. If for some reason the Army Corps of Engineers didn't provide approval and didn't find a way, couldn't find a way to see compliance with federal standards, then this would absolutely have to be brought back to the board. Again, for another hearing on removal because it's unpermittable for some reason. Again, I think as Mr. Countryman has indicated, that's unlikely, but
I think that's right. And if it's delay from the Corps, and it makes sense to have that be something that we do then under normal procedures, because if it's delay from the Corps, it's a problem for us. It may not be the landowner's fault. If it's the Corps isn't processing something because there's information that's needed that's not being provided, that's a different story. But I think we're covered for those scenarios with this motion myself. Records show that our board counsel is nodding.
Yeah, I told everybody not to nod their heads, and I'm nodding in agreement. I'll confirm your statement.
We have a motion.
Is there a second? Did you make it?
I made the motion.
I'll second the motion.
Okay, we have a motion by Board Member Griego, and I'm not going to restate it because it's in the transcript, and we all made good notes, and a second from Board Member Countryman. Would anybody like to debate the motion one more time before we have a vote? Saying nothing, let's call for the vote.
Member Andrews?
Aye.
Member Bosler?
Aye.
Member Countryman?
Yes.
Member Griego?
Yes.
Secretary Johnson?
Aye. All right, that motion passes. Let's do a time check here. It's 12:20, and we have two what could be fairly lengthy permit hearings coming up before going to other DWR presentations. And so my instinct is we need a break, and also to push ourselves to make it a pretty manageable size break where, maybe we're getting a snack and caffeine, but not leaving the building and going out for lunch. If I restart at 12:45, is that too much time? Okay, I'm going to be prompt. We really will start again at 12:45 with our next agenda item then. And for now, we're on a break. All right, everybody. Not quite 12:45, 12:47. We're still waiting for Board Member Grego. But this item here, 9B, she saw last month, and so I trust her to come up, catch up, and we do have a quorum. This one it starts with Travis Comstock presenting its permit number. My eyes are not good. 19916. It all is cross levee fence project in the Big Pocket area, and you know, since we did hear this last month, I'm not going to tell anybody that you shouldn't repeat things that you said last month, but it's only been a month, and so I'd encourage you to use your judgment about what you really need to reinforce, knowing that we have the material, and also encourage everybody here, if they have something that's different or that's changed, you know, to call that out so that we get that. And with that, go ahead.
Thank you, Secretary Johnson, for that reminder to keep it brief. Again, my name is Travis Comstock, board staff, and I am here to present once again the Nadal Cross Levee Fence and Stairs project in the Big Pocket area. This is for permit number 19916. And as a reminder, this was a continuance from last month. Next slide, please. So this project seeks to install a cross-levee fence and 14-foot wide double-leaf gate, as well as some concrete steps on the landside slope. Next slide, please. Here we can see that the project is located on the north end of the Big Pocket at 725 Clipper Way. Next slide, please. The fence is going to be on the left bank, going from landside toe all the way to the water's edge. Next slide, please. Here we see the red outline is the fence, and the yellow box are the stairs. They're on the landside slope. Next slide, please. Just as a brief reminder, the Army Corps did begin work in 2020 on improvements along the bank of the Sacramento River. This project area circled on the map on the left there, where the applicant's property is located, that portion was completed in 2021. Next slide, please. Prior to the Army Corps work, there was a permanent cross-levee fence that existed at this location. It was approved by the board in November of '92 and then reissued in April of '95. Next slide, please. As a way to ensure that there were no delays to the federal project, an incentive was offered to the applicants to get them to remove their encroachment. Next slide, please. They entered into this agreement, and part of this agreement reminded the applicant that state law under Title 23, Section 6 required every plan of work in a floodplain, in an adopted plan of flood control area must be approved by the board. Next slide, please. While the Army Corps was doing their work along the levee, the applicant did seek a temporary cross-levee fence in early 2023. This was approved on May 16th by the board under a minor alteration, Work Authorization 2023-078. Part of this temporary cross-levee fence application required that the applicant get an extension every 4 months, and their most recent extension is set to expire on July 1st. Next slide, please. During this time, the applicant also submitted an application for a permanent cross-levee fence on April 18th, 2023. This application, after a little back and forth with a design, was sent to the Corps on October 2024, and we received a letter of permission from the Corps on April 28th of this year. Next slide, please. different elements of this project and how they relate to the code. The landside fence panels will be 6 foot high and 8 feet wide. This is the same for the waterside fence panels. However, the fence panels on the waterside will be removable. This complies with section 126A5. The 14-foot wide gate across the crown meets the requirements of section 126B1. Next slide, please. The stairs themselves will be constructed of materials that are resistant to deterioration in accordance with section 137C1, and the stairs will be built flush to the landside slope, meeting section 137C4 requirements. Next slide, please. Board staff reviewed the hydraulic blockage calculation that was done in accordance with Army Corps Section 408 categorical permission standards. This looks at the total cross-sectional area and the area of the obstruction and creates a ratio. Anything over 1% requires additional hydraulic analysis. This calculation resulted in a 0.96% blockage, resulting in no additional analysis for this project. Next slide, please. There will be some ground disturbing activities which board staff reviewed. The footings for the fence panels themselves will be at a maximum depth of 18 inches, and for the gate at the crown, there will be a maximum of 16 inches excavation depth. The stairs will be 12 inches into the slopes, and there will be 4-inch thick landings at the top and the bottom. All fence posts will be embedded in concrete, and no seepage or stability impacts were anticipated to affect the performance of the levee. Next slide, please. Here we can see the applicant's parcel shown on the left. It goes from Clipper Way all the way to the water's edge, and the image on the right shows the SSJDD easement layer in green there. We can see that the easement layer and the applicant's parcel overlap, requiring anything built in this area to get a permit by the board. Next slide, please. Board staff conducted a CEQA analysis under Title 23. Specifically, Section 15300 gives a list of classes of projects which have been determined to not have a significant impact on the environment. This project falls under 3 of those classes: Class 2, replacement or reconstruction; Class 3, new construction of a small structure; and Class 4, the minor alteration to land. Next slide, please. This project was endorsed by the local maintaining agency, which is Maintenance Area 9, on February 22nd, 2023. And again, we do have the letter of permission from the Army Corps. We got that this year of April 28th. Next slide, please. The board is granted authority to regulate the levees under Water Code Section 8534, 8590 through 8610.5, and 8710. Specifically, Title 23, Division 1 gives guidance for the need for a permit, Section 11, the variances, Section 12, any protests, and specifically for this project, Section 126, fences and gates, and 137, the miscellaneous encroachments. Next slide, please. Thank you. Following Water Code 8610.5, ask that the board consider the following. The blockage calculation conducted by the applicant meets Army Corps and board standards and demonstrates that the proposed encroachments will have negligible effects on the conveyance of flood flows. The project was coordinated and reviewed by Army Corps Section 408. The backfill procedures and footings were approved by levee safety, and they also found no impacts to the performance of the levee. And lastly, the proposed project is not anticipated to result in any adverse effects on facilities of the SPFC. Next slide, please. As a reminder, the city did submit a protest letter on the last month's hearing, and again, for this month's hearing, we received a letter on June 24th, 2026 from the city. They're seeking denial of this application by the board, stating that approving the cross-levee fence would be in direct conflict with their future shared use trail, and it would create a physical barrier blocking public access at this location. Next slide, please. And trying to allow the applicant to build their encroachments while still working with the city, board staff worked with council to develop these special conditions. 14, that the permittee acknowledges encroachments may be affected in the future, and upon written notice from the board that the permittee shall remove at their cost and expense the encroachments and restore the levee to pre-project condition. Next slide, please. And the second special condition, that upon recordation of a change in property rights from private to public access affecting the encroachments permitted herein, this permit will be revoked or modified as determined by the board. Next slide, please. With all that being said, board staff asks that the board adopt the CEQA findings, approve permit number 19916, and direct the executive officer to take necessary action to prepare and execute the permit and related documents, and to prepare and file a notice of exemption with the state clearinghouse. Next slide, please. Any questions?
Questions from the board? Okay, thank you. So our process here is we'll hear from the applicant next, and then we will take public comment, and then we'll close the public comment and come back to the board. I believe Mr. Manning is going to be making this case. Thank you.
Thank you. Brian Manning, Desmond Law Firm. I have a quick presentation. Thank you all for taking the time. If we can pull that up, please. So I did have a chance to review last month's meeting, and sorry I couldn't be here, but I was adequately, more than adequately represented. So going to the next slide, I just wanted to give a quick overview of the general location and to make sure that we're all clear on what we're dealing with. So if you look at, that's the big pocket. Up on the top side, on the north side of it, it's a little bit hard to see, but there's some red writing. That is the end of the bike trail that goes north towards Old Sacramento. Down on the bottom where it says Garcia Bend Park, there's some red writing. That's the end of the bike trail as it goes south towards Freeport. That entire section between those two lines is not a bike trail. There are no recreational rights for the public within that area. So to the extent that you hear otherwise, there is not a bike trail there. And that's been the subject of, completing that bike trail has been the subject of a decades-long process. If you go to the next slide, please. This is the segment, this is the first in a series of 4 permits that are going to be requested to put back fences that have existed for decades. And I know there was a comment last time, well, why do we have 4 fences instead of 2? The reason is because in that middle section, there's public access up that way, right there right in the middle. And so you can't have the 2 fences on either side, the north-south, because it would be ineffective. The public could still get up there. So if you go to the next slide, please. That's just a closer view, and you can see that's the North Point Way access point. There's a ramp there that has been constructed as part of the flood control project that allows folks to get up there. And there are actually public rights within that area to walk on the levee, but it's not an official bike trail. If you go to the next slide, please. This is the first segment. You have 725 Clipper, this is Nadal's property, upriver, and then downriver is 700 River Lake. That's going to come before the board at a different time. But that creates a segment of protecting private property rights from public using that levee, essentially these folks' backyard, for public access. They have no rights to go up there. It is trespassing. And I just want to make sure that's very clear. I don't think it's not disputed that the public doesn't have any rights up there. to go utilize that for whatever purposes they want. That is private property. And if you walked on that levee, you are trespassing on somebody's private property. Go to the next slide, please. This is the, on the right-hand side, that red line is not the fence, so don't get it confused with the slide that was presented by staff, but that's the end of the bike trail. Bike trail ends there. That's Zacharias Park up to the, off the screen there, but that's where you would get off the bike trail and be able to go on to not busy streets, but streets that are, neighborhood streets. So if you go to the next slide. The issue here is, again, there's no public rights for recreation. SSJDD does have an easement, but that easement is, it's limited in scope. And so what I have up there is a case from 1896, a black letter unquestionable statement of the law that any easement holder, which SSJDD is, and you're enforcing those easements, has to use their easement in a manner that is the least burdensome upon that servient tenement. And they have no right to render or operate their easement so as to render a nuisance or destructive use of the servient tenement. So that's important to recognize that these folks, despite there being this flood control easement, they retain tremendous amount of rights in their own property. They have the right to exclude others. They have the right of privacy. Unless and until that right is taken from them, they retain those rights just like you do in your own backyard. The next comment there is from the regulations. So this would normally just kind of be a no-brainer, no big deal, this type of application. But we have a lot of passions about opening up the river, which is understandable. But I want to make sure that the board, this code of regulations, all protests regarding these permits, any permit really, but protests regarding the permit must be based solely upon flood control concerns. Solely. There's no discretion otherwise. That is the regulation that this board has to comply with. And then on the right-hand side, these are the bases that the board can utilize to deny a permit. Every single one relates to flood control impacts. And that is critically important to understand what the role is of this board as it relates to this application. Next slide, please. So, as it relates to flood control issues, which is the only thing that we should be here discussing, every single agency, DWR, local maintaining agency MA9, Army Corps of Engineers, have all endorsed this application. They are the pros. They've said, as you saw in the initial presentation, there is no anticipated impact on flood facilities as a result of these cross-levee fences. These cross-levee fences were there for decades without issue. The owners have never been cited for issues with the cross-levee fences. They've done everything right all along throughout this process and for the decades prior to that. And I want to particularly thank staff as we have dealt with this issue since 2021, when the Sacramento River East Levee project first came about that required these fences to be taken down. And I represented all the owners that had encroachments out there, and it was very clear. You have to take those things down. That is the regulation. That's the law. And we were able to work cooperatively with staff to be able to get temporary rights up there, temporary fences up there to ensure that property owners' rights were protected during this temporary phase. Now we're back to get the permanent fences reestablished. So generally, as I said, this should be a no-brainer. I mean, cross-levee fences are usually delegated to the executive officer as a minor encroachment. And these cross-levee fences are de minimis compared to what else could be out there. So what I think is important is that from a flood protection standpoint, there is simply no basis to deny it. And that's the only consideration that must exist. And so to the extent that there's going to be there has been significant comments that were presented. So if you go to the next slide, public comments that were presented via email, and I'm sure we'll hear from some folks on the telephone, and they have every right to speak their mind as free country, obviously, and you have free speech. But when it comes to the considerations that they've all put forth, they are irrelevant for these proceedings. And I think a lot of them establish why it's so important that these cross-levee fences go up. And I've selected some of the statements that were made. You could read those for yourself. But basically, it's don't allow these to go back up because we want to access these properties. When they were down, it was wonderful to see people walking and running across. That's like saying, don't go put up a fence in your backyard because we want to go utilize your backyard. Unless and until the city takes these properties and the rights of these folks, they have a right to protect their property. And the public sentiment right now is these folks should not have the right to protect their properties. Well, that's not within the purview of this board. That's the city's responsibility. And I'm not disparaging their positions. I understand it. But our concern is that based on what you've seen here and what the comments have been, and the city, that by denying these cross-levee fences, you are de facto creating a trail because there's no enforcement proceedings. Part of the city's process for going forward with their bike trail is they're going to come up with security plans. They're going to come up with things that they say are necessary in order to protect privacy, security, etc. That hasn't happened. So if you denied these, you're opening up the trail to the public to walk on, to do whatever they want to do, illegal activities, without the protections that should exist as part of the bike trail permitting process. And so if you go to the next slide, the city's comments, which was kind of a basis for last time extending this, they didn't come with anything new. There are no flood protection concerns that they have. Their concerns all relate to their bike trail project. That's irrelevant for your consideration, period. Under the law, that is irrelevant. And I also want to point out that it's misleading that what they're saying is going on. They're making it seem like they're coming out tomorrow and making offers to people and the bike trail's going in. The bike trail is years away. That's just a fact. We've heard already that the 408 permitting process takes years. They haven't even submitted their application for a permit to this board. They don't have the money as it relates. So what they're talking about taking properties, all are south of these properties. It's up to Audubon Circle. So it's from Garcia Bend Park up to Audubon Circle. That's where they're taking next. They tried to take properties years ago, or property rights years ago, and then abandoned it. They don't have the money to take properties that exist behind these cross-levee fences. They have I don't remember how many tens of millions of dollars in deficit that they have right now. But when they get that money to take property rights along these owners' properties is completely unknown. This thing has been around for decades. So what these folks are trying to do is protect their property until the city actually complies with their rights and says, we're going to be taking your property rights. We're going to be allowing the public to go onto your property, which the city has the power to do that. There's no question about it. The city can come and say, we're going to take these rights, and we're going to create a bike trail here. And I'm sure I'll get a few calls when that happens, but right now, that hasn't occurred. So the idea that going forward with allowing these fences to go back up makes it more difficult or makes it more expensive or complicated, it's frankly untrue. And it's I don't know, a scare tactic or something. That's not the right phraseology, but it's not. The power of the eminent domain, as this board knows, is tremendous. And the city comes in and says, we're taking it, they're taking it. And they have the power to do that. And so these cross-levy fences will not make that more difficult. It will not make it more expensive. And to the extent that anybody on the board thinks that adding these fences back would increase the value, I would say that denying these fences decreases the value. And then you've set yourself up for inverse condemnation by denial. So these fences existed. They have a right to protect their private property, and they need to go back up because there is no basis under the law as it exists to deny. Flood control is completely protected. Every agency has signed off. You go to the next slide, please. And I think the most important thing that you heard in the initial presentation was that these cross-levy fences are not anticipated to adversely affect flood control facilities. That's all you needed to hear. And on that basis, it should be approved. And I'm happy to answer any questions you have.
Thank you. I'm going to start, actually. The city process, I hear you say that the timing is uncertain, but the city could acquire the public access right away or easement. I agree. And I want to be clear that your client's understanding is that when that happens, you'll remove the fence, the client will remove the fence, so that part of it that's across the public access, and that's how this is going to go.
If the city, as part of their process, says we want those fences removed, they have a right to say those fences need to be removed. And then we will comply with the city's exercise of eminent domain, or constitutional exercise of the power of eminent domain. They have a right to say that.
Yeah.
As part of our project, you've got to take those fences.
I got you. I just want to make sure that we're understanding. And the reason is because this is partly for my fellow board members here too, is we have the permit term 15 that was addressing this. And at the last meeting, I had an exchange with our board counsel, and I was seeking to confirm that when that public access right changed, that the fence would be removed, and it didn't require more work in us, months, doing permit changes. And the language we had then said that it would be would happen automatically. And I want y'all to notice that the language we have this month is a little bit different from that. It says, upon recordation of a change in property rights from private to public access affecting the encroachments permitted herein, this permit will be revoked or modified as determined by the board. And there are a couple of good reasons for this. One is if we just say the permit is invalid once the property right changes, that's suboptimal because we'd rather have jurisdiction to ensure how this works, and also because the encroachment permit may cover structures that aren't in the public access area, and so modification would be the right approach. So that's why that is there. I still was concerned that there might be a little lack of clarity as to exactly how this would happen, and I want to make sure that the removal part of it is done right away, and while the board is deciding, how to modify. And so I asked staff for an edit that I'm going to make part of my recommendation. Do we have it here? I can read it. It's basically the same thing, but also clarifies that the permittee will remove the part of the encroachment that's in the public access right away. So what I've got is, upon recordation of a change in property rights from private to public access affecting the encroachments permitted herein, the affected encroachments shall be removed at the permittee's sole expense within 30 days notice from the board, and this permit will be revoked or modified as determined by the board. I think that's more clear about what we're intending here.
I would, it's kind of, we're going out on a bit of a limb, but to the extent that an eminent domain action is the basis for requiring the removal, there should be no expense upon the landowner to remove those encroachments. That is the city of Sacramento saying, we're coming in, we're taking your property rights, and as a result of taking those property rights, we need to, these cross-levee fences would be interfering with those rights. Okay, well, the owner in those situations never incurs any costs associated with that project. And so to the extent that you have in there your sole, at the owner's sole cost, that's a concern I have.
I'll go to board counsel and also say that we'll discuss all of this as part of the motion, and so I appreciate your comment there, and we'll go to board counsel. We'll take other questions for Mr. Manning, and then we'll go to public comment.
Thank you, Secretary Johnson. Board Counsel Dua. Just wanted to share with the board some of the thinking behind that language, and the reason the expense is passed to, or the intention that the expense is passed to the homeowner is because the eminent domain proceedings and the cost to acquire the property is assumed to cover the fence as well, and so that would be captured there, that they're removing the fence as part of the overall compensation that they received.
Okay.
Okay, thank you. Other questions for Mr. Manning? Okay, so thank you very much. And we're going to go to public comment.
Just an order of procedure.
Sure.
Under the regulations, I do have a right to come back up if necessary. So after public comment, after any protests, I do have a right to come back up. Just, I don't know if I will need that right, but I want to make sure that that's clear.
We're going to make sure that you have an opportunity to say what you need to say.
Okay, thank you.
Thank you. Okay, so public comment here, and reminder that we do these 3 minutes apiece, unlike the applicant who gets more time. And given that we considered this last month, I'm going to try to keep you to that. So please don't have me cut you off. I'm going to go in the order that I've got these here for 9B, and then we will see if there are other people in the room who didn't submit a card, and then online. There are a couple of people I wasn't sure if they were 9A or 9B, so I'll just ask at the time. Don Murphy.
Okay. I'm Don Murphy. I own two parcels, 7250 and 7260 Pocket Road. My property really goes back to the late 19th century when the farmers developed that area, and I'm about the third owner of the property. My property was granted easement rights to the government agencies for flood control and maintenance. Now, I'm not going to elaborate on what Mr. Manning has perfectly described, but I want to bring up an issue that I just thought of, and that is easement rights, for example, for a recreational easement, doesn't necessarily mean that the party who gets those easement rights would own my property. My understanding has always been, and I've checked this legally, I own the dirt under the levee. The farmers that originally worked that land and owned that property, they built those levees, not the Army Corps of Engineers. Army Corps of Engineers now maintains that property, as does the DWR and the flood board, but we're not giving up our property. So I'm confused about the comment that was made about taking the fences down when the property is acquired. It's the easement right that's being acquired. Now, you've got legal counsel that can probably guide you on that. The second point is that the Nadal fence is about 4.5 miles upriver from the last fence down the river at Billy Ann Groza property at 7454 Pocket Road. That's the fence that I referred to earlier that's constantly vandalized. Trespassing is rampant, can't be stopped. So if the Nadal fence is not authorized, the eminent domain process is going to start with myself and 5 of my neighbors. We're the last little group of people that are the private property owners on that levee. The city came after us a few years back with their eminent domain, the resolution of necessity, and all those threats, but the construction project slowed that down. They have not approached any of us in the recent past about right-of-way access. That hadn't even started, but I'm really strongly under the impression they will come after us first. So if you deny this fence of the Nadal fence, and then it just seems like it's going to be so convoluted that you're taking away her privacy, and it makes it a lot easier for them to take us out down at the southern part of the levee. And I wanted to just mention a couple of things. Is that okay?
You're at 3 minutes.
All right.
Thank you.
I did some research with the framers of the United States Constitution.
I'm sorry.
You're not gonna-
We're running way behind today. We're going to keep the public comments at 3 minutes.
It's a
We've heard from the
life-changing-
applicant.
Okay. It's a life-changing event. I thought I could just mention a couple of other things.
Thank you. Okay, our next public comment looks like Billy Ann Groza. Do you have that? Nope. We have a Ryan Bogle, I believe.
All right, thank you, members of the board. My name is Ryan Bogle. I live just south along the levee, just south of the proposed fence. We're here today because the city asked for 30 extra days to address the issues of these cross-levee fences. In those 30 days, basically all they came up with was, we have a project that we want to complete. The city is years away and millions of dollars short of attaining the necessary easements needed for this section. And for them to object because they have the plan to complete their project at some unknown date in the future is putting the cart before the horse. I understand the statements of the bike trail advocates who want to use the levees and create the continuous bike trail to Sacramento. But what their statements makes crystal clear is, absent these fences, they will begin using the levees immediately. So one thing about the condition 15 that I do have a question about, eminent domain process could happen sooner than later. The city needs to complete eminent domain to attain the recreational rights to move forward with their permit application. We all know this permit application is timely, and the 408 process through U.S. Army Corps of Engineers could take many years. I'm sure the city will fast track it and move it as fast as they possibly can. But one thing I do worry about in that language is if those fences have to come down as soon as they obtain easement rights, there will be no security or safety plan in place because the trail will not be complete. And so I would just ask that perhaps there's a way that the condition of the fences coming down, if approved, is pushed off until the city has completed the funding and paving of their project. Again, we continue to be vilified as landowners for simply asserting our private property rights, and you, as the board and the staff, continue to be vilified just for following the water code. I kind of blame the city for this. They're not doing a very good job on communicating this to the public. All of this, the time it's taking to get this done is on them. So this application has been awarded all necessary endorsements and meets all the criteria and conforms to all standards under Title 23. Again, I ask you today to approve this permit. Thank you.
Thank you. Our next public comment is Bill McClendon.
Hello, my name is Bill McClendon. I reside at 692 River Lake Way. I've lived there for over 11 years. It's a probably good afternoon, Secretary and members of the board. Contrary to misconception, I own the property directly behind my home, which extends from my rear fence line across the levee crown to the edge of the Sacramento River. I want to thank the board and the staff for your dedication to reducing catastrophic flood risks across the Central Valley's 1,600 miles of levees, and for thoroughly outlining the facts regarding this proposed cross-levee fence. In summary, the record will show that the LMA fully endorsed the project on February 23rd of 2023. The Army Corps of Engineers issued its letter of permission on March 28th of 26. The project fully complies with all hydraulic, blockage, geotechnical, and CEQA requirements, regulatory requirements. In short, this cross-levee fence has zero negative impact on the flood control. Furthermore, any future municipal plans for a bike trail have no bearing on the engineering and safety merits currently before the board. So given that all technical, environmental, and engineering benchmarks have been satisfied and supported by both the local management agency and the Army Corps, I respectfully request your approval of this permit. Thank you for your time and consideration.
Thank you. The last comment card I have doesn't say if it's 9B or 9C, and I have others that are definitely for 9C. And it's a Richard, but I'm not sure about the last name, Wilson possibly, or if there's a Richard here who wants to be part of 9B, come on up. Okay, so that's the last of the cards I have. We will. I have a Patrick Henriksen for 9C, but if you want to speak for 9B, please come up to the podium. And then anybody else who in the room for 9B will come up after that, and then we'll go to the phones.
These kind of dovetail together. My name is Patrick Henriksen of the Law Office of Patrick Henriksen of Sacramento, California. I'm pro bono counsel for James and Karen Silva, who are sitting right here in the front row. My wife is also here. She is a board member of the RVIA, the Riverside Village Improvement Association, of which I'm counsel for the board. I want Jonah to pull up condition 15, please.
Could we get condition 15 pulled up?
Can you do that for us?
They're getting that pulled up.
Thank you. Prior to it being pulled up, I did in fact have a conversation with Mr. Dua to specifically go over that condition, which I have no problem with as stated in your staff report. You cannot revoke it automatically on a recordation of a public easement, and there's a reason. The last time in the meeting on May 22nd, there was a safety concern. Mr. Countryman was kind enough to ask the city employees, "You're not going to let them through at night, are you?" And they said, "Yeah, of course we are, with headlamps." This lovely lady, who just left to go get parking, more in her meter, is my wife, right? And she, when I'm not around, is deathly afraid of having somebody come through our backyard. That's not going to happen even if there is a bike trail. So there needs to be another hearing before this board, an educated hearing with facts to determine the city's safety, right? What are they going to have? they're going to have attendance at both of our gates. So why take the gates down? Just switch the name into the city and make them maintain them. That's the purpose of that condition 15. So don't change that. Don't automatically revoke it, because then we have to go through the entire application permit. This one for the Little Pocket took me 600 hours. I had to start with Micah Wright coming to my office along with Selva, right? Ryan Thyberg. I had to have meetings with Army Corps on teams with 14 members. I had to deal with Carolyn, the Army Corps attorney. I got to know all of you, right? I wrote a letter directly for Ms. Griego because of her poignant questions at the last meeting about safety. I've become quite enamored with your questions, honestly. So we talked to Casey Lund, right? Casey Lund knows every single one of you, and he says hi. Okay? In the Little Pocket, we have two, an east and a west gate. Very simple. We have an access at Piedmont, and we have Knox boxes. Does everybody know what a Knox box is? It's an emergency box that you purchase, gets registered, and you have to have a firefighter employee come out. And those photographs that are sitting in front of you show the firefighter putting the key for the daisy chain for each gate into the Knox box, which should be your standard of care for every gate in this community from now on. Our gates in the Little Pocket are insured
That's
for
3 minutes.
are
Thank you.
insured for $5 million. Okay? Don't change condition 15.
Thank you. Other comments here in the room? And we'll just have people come up and address the podium since I don't have the card. Say your name first, and we'll go through those, and then we'll go back online.
My name's, excuse me, my name's Hal Sterrett. I am also a property owner in the Pocket area, except my property doesn't happen to extend to the river, so I don't share in these folks' entitlements. So, as I understand it, the flood risk protection is your responsibility. But by what legislation does the board have or is commanded to protect the privacy and property rights of property owners? And I understand that you can deny the construction of things, but do you have the right to grant the ability to build a cross-levee fence? I represent a group of people. We're the Pocket Greenhaven Bicycle Club. There's about 40 of us. And we really would like to see the completion of this river trail. And we've been waiting for years for this to happen. And as far as privacy, if you've ever ridden on the trail south of the gates where it's paved, you'll see plenty of houses who back up to the levee, and they don't seem to have too much problem with the fact that there are members of the public up on the levee, walking, riding, doing whatever. And yet the people, the small group who are here trying to protect their supposed property rights, because I don't recognize that they actually own the levee. They may own the property underneath, but taxpayers have seen that these levees are maintained and constructed for everyone's protection. So, and I also have evidence that there's no difference in crime levels south of the fences as compared to within the closed-off area that these people want to keep. So I highly, highly recommend, and I speak for my group of cyclists, that you deny this permanent construction, especially with the idea that for the whole city of Sacramento, this river trail will be a big benefit, and it will really be something in the public good. Thank you very much.
Thank you. Do we have other people in the room who would like to make a public comment? Not seeing one here. Let's go online. Our board clerk will call on people. Raise your hand virtually if you can.
Richard Markuson.
Yeah, good afternoon, I guess, members. This is Richard Markuson. I'm a 40-year resident of the Pocket area. My concern isn't just item 9B and 9C at Clipper Way and Piedmont Drive. My concern is that the board is being asked to evaluate these permits one at a time. There's obviously been reference to other permits that will soon be before the board, without any total discussion about the cumulative effect on how they relate to Sacramento's longstanding plans for a continuous river parkway. Staff seems to be treating these as isolated permit applications. My belief is before approving another permanent encroachment on the public levee, the board should step back and ask whether these individual decisions taken together are gradually foreclosing future public options. I believe, and many others, once permanent structures are approved, they become much harder and much more expensive to remove or redesign. In fact, there's been considerable debate and disagreement tonight about whose responsibility it's going to be for them to be eventually removed, which is exactly why I think that the board should insist on seeing the bigger picture before acting. I don't believe that the board should make access policy by permit. Before approving items 9B and 9C, I believe the board should first ask staff to identify every temporary and permanent gate permit pending or approved along the corridor, explain how they affect the city's parkway plans, and tell us and you whether the decisions will increase future public costs. One other thing, I noticed a couple of speakers talked about the endorsement or approval by, in particular, the Corps of Engineers. I don't think that's an accurate description of the issuance of the letter of non-concern or letter of no permit required. It's one thing to say that the Corps is not going to object to a process, to characterizing that as an endorsement. An endorsement would be the Corps saying, yes, these should be constructed. And I don't think, with all due respect to the speakers who have called it an endorsement or support, I don't think that any of the public agencies who have reviewed the flood impacts and found that there is no concern that those should necessarily be characterized as an endorsement. I think that's a misstatement of fact and their purpose of their participation. I appreciate the opportunity to speak to you again on this process, and I hope that the city does get an opportunity to complete the long-planned improvements along the levee. Thank you very much.
Thank you. Coming in at 2 minutes and 55 seconds. Jonah, who else do we have online?
No more hands raised online.
Okay. My process notes didn't have responses, but Mr. Manning, I'll take your word for it. If you have something you want to say, I want to give you a chance to say it, and we'll do the same thing for board staff after you speak.
I just wanted to say one thing. The Constitution guarantees private property rights. The government agency cannot do anything or make any laws or make any decisions that abridge or deny those rights. That's it.
That was Brian Manning.
Greg, do you? I thought maybe you wanted to address the city's letter or anybody from staff, but I'll leave it to you to decide how to have the last word here, and then we'll take it back for board discussion and possible vote.
Thank you, Secretary Johnson. Yeah, just real quickly, we did receive, Greg Harvey, board staff. Thank you, Jeet. We received the letter from the city, and we evaluated that. And which has already been spoken today, we evaluate permit applications based on flood control measures. And currently, as it stands now, the easements in that particular area are for maintenance and there are no recreational easements. And so we're evaluating these on a case-by-case basis, and we're a neutral party. We're not opposing fences. We're not pro fences. We're looking at these in a flood control aspect. So just wanted to reiterate that. Thank you.
Thank you. All right, with that, we'll close the comment part of this agenda item, and we'll bring it back to the board first for a discussion and then for a potential vote. Who wants to start? Board Member Andrews.
Thank you. I appreciate all of the commentary from the neighborhood. I understand your concerns. Thank you, Trevor. And I understand the interests in public access along bike trails, having ridden many miles along the Sacramento River in my lifetime and enjoyed it mightily. And I'm inadvertently on the line, not doing that. I had questions about conditions 14 and 15. 14, I think this is just my lack of familiarity with some of probably typical language, but there is reference to access required by any authorized project without specificity about the nature of that authorized project. Is it assumed to be a certain type of project?
It's Board Counsel. I'll speak to that. Condition 14 is, although it's called a special condition, it is standard model language that board staff uses in permits, and that is an anticipation of any future flood control project. So condition 15, special condition 15 was added specifically to deal with the cross levee fences if they are so approved.
So we're not, it would not be the case that someone could construe authorized project under condition 14 as being the city's bike trail project? Is that?
That is correct. That's why we have condition 15.
Okay.
We specifically speak to a change in the nature of the property right from a private to a public access right, which has been stated. The easements that the board has, or the SSJDD has, which is managed by the board, are for flood control. And for access, it's for operation and maintenance of those facilities.
Thank you. And then with regard to condition 15, thank you for presenting specifically the proposed language. I'm wondering if you could summarize what the city of Sacramento requested as language for condition 15 and tell us the implications of it relative to what the board has proposed. Is there a substantive difference that we should be aware of?
This is Board Counsel again. Yes, thank you. So the city has proposed that not upon recordation of their right, but once a court issues an order granting possession. And so there is a difference because the public is not put on notice until it's actually recorded. And that's why we have chosen that term specifically. And I think it's the appropriate term. Obviously, the city can record their judgment the following day or even that day, depending on when their order is. And that's entirely up to them. But that's when it would become effective.
Thank you for that clarification.
We'll go to Board Member Grego, but then I think it might be helpful to get the language that I suggested for 15 up on the screen if we can. And according to tradition, I'm not going to make the motion. I'm going to put it there for you all to consider. And I think the thing that I've concluded for sure from listening to all of this is that we should be very conscious about what it is that we're doing. And, so we'll discuss that and, we'll consider any motions that are made. Board Member Grego.
Thank you. So I would like to discuss under agency conditions, item 25, and that has it relates to item 44, I believe it's, yeah, 44, under operations and maintenance. I'd be remiss if I wouldn't talk about evacuation planning or high water events. And so I want some clarification in regards to high water event. What is it? Where can our staff tell us what that classification is? I mean, there's different, levels of high water. I just want to know, can you tell me specifically what that means?
Greg Harvey, board staff. What was your question again? I apologize.
So it says that under item 25, condition 25, the removable sections of the fence are not removed during high water events. The permit may be revoked. What is a high water event?
So high water events are where the water actually reaches the fence. So the sections on the water side are removable. So I guess a high water event's a generic term, but it's when the water comes and hits the fences. They're supposed to be removed by the permittee. And if they're not, then the maintainer or DWR or the board has the right to remove those fences for maintenance.
So should there be some clarification under that condition so that everybody understands what that means?
There could be. I thought there were other conditions in there that spoke to that. If there's not, then we should add that.
If there is, I missed it. I'm sorry, but I didn't see it. The other part of this question is in regards to locks. I'm interested in how our state maintenance area folks are going to manage that. Sometimes locks get changed. How do you manage that?
So the maintenance area 9 has access to all the locks, and like Mr. Hendrickson said, there are also Knox boxes that have for police and fire and maintenance, and our board inspectors have keys. DWR has keys, so if a lock is changed, then I guess it would be cut, and then a new lock would put on, and new keys would be distributed.
I guess under those conditions, that would also be granted a reason to revoke the permit. Is that correct? Under condition 25?
Well, it would have to be determined if, a lock was changed intentionally by, somebody. We'd have to figure that out.
I'm just concerned about maintenance and operation and high water events, that they have the ability to get in there and do what is necessary.
Right.
So,
yeah, it's a grave concern.
Yeah, thank you.
More discussion here? Should I read this again since I don't know if we have the ability to change what's on the screen? Do we? Go ahead, Board Member Andrews.
I realize I may have left a misimpression by recognizing the interests of all the parties in the room. I agree that the focus of this board is strictly on flood risk reduction, and our authority is with regard to managing the flood system. And I appreciate the work that our board member and staff counsel, board counsel, rather, have done in crafting the language that will allow what I think is the right resolution here, which is coexistence of the property owner's right to erect the fence on their private property until such time as a different right exists in terms of access. Thank you.
Board Member Grego.
I agree with Betty in regards to that comment because I'm a strong advocate for recycling. But this permit is before us today, and this is our task, is to either give it a thumbs up or a thumbs down. And I have to support the process. But when the city has the ability to acquire those easements through there, I can't say that I won't be unhappy about it. I love seeing public access. But I also think that this gives the homeowners an opportunity to really try to work with the city in regards to the public safety issue. there's a lot of homes that run up alongside the levee systems. And in Yuba County, it's the same there. They do have their problems, but it is a law enforcement issue, and they deal with it. So I would encourage property owners to engage and try to find solutions, because this is not the only area that will have public access along a housing area. There must be some kind of solution out there that might remedy some of this concern. Thank you.
Board Counsel Jeet Dua.
Thank you, Secretary Johnson. I just wanted to add for the board's awareness that staff and myself, in working through this issue, recognize that the applicants anticipate trying to work with the city on some of these safety plans. And certainly staff is going to honor any agreement that makes sense for them, as long as it meets our standards and satisfies the flood control's concerns, if any.
Right. So I'll ask again if we can get the language up, or if I should go type or read it again. But I'll tell you the reason it's on the table for discussion. Our permits generally are very clear that that the board has a mechanism in one of the other standard permit terms to order changes with encroachments that would be made within 30 days. And the question is whether that section would automatically work for this when the change of property rights happens. And my interest is in being clear that it can, the way that we would normally with an encroachment for something else. And because of the possible uncertainty and making sure that expectations are set, I think it's a good idea to include that ability to order just that portion of the encroachment that would be within the access area to be removed or opened, and then to come back and decide what happens to the rest of the permit. So that's the purpose of it, and that's all it says. It's exactly the same as the prior one that's in the report, with the addition of the removing the encroachments. So upon recordation of change in property rights from private to public access affecting the encroachments permitted herein, that's the same. And then would add, the affected encroachments shall be removed at the permittee's sole expense within 30 days. Notice from the board, comma, and then continue with what was there, and this permit will be revoked or modified as determined by the board. And that's the intent. And I believe that the process with the city and who pays would be worked out as part of that, because the payment for the right-of-way would include this. But my concern either way is that the city's not a party to this permit. And so, our normal thing that we've always done and everything that I've seen is to be clear that we know how to work within the permit for the person who is covered by it, who's the applicant.
Through the chair.
Board Member Grego.
I have a question for legal counsel. I've been a part of probably over 50 intimate domains, but not for a recreational easement. It's always been through fee title. And so my question is that when an agency goes through that process of intimate domain, and that's what we're talking about, is a change in the use of that specific area, do they have to prove that they have a fully funded project at the time of that proceedings?
Well, Board Counsel, you might want to bring Mr. Manning up here since he's the inverse condemnation expert in the room. But the city has to have funding, or the public agency typically makes an offer first.
Right.
And then the property owner has a right to have its own appraisal done. and a negotiation ensues from there. And if agreement can't be made, then the city, or I shouldn't say the city, the public agency or whoever it is that has the authority to exercise that power of eminent domain would file a condemnation suit to obtain that. And so then it's becomes a litigation matter at that point before the courts.
The reason for my question is because I didn't know if they had the ability to come in and file those actions and then all of a sudden sit on that for a permit, for a while, where we would then say, okay, the fence is going to be removed. Would that happen immediately, or would there be the ability to have time between that space of when it happens and when the fences come down? I'm just thinking in advance of what could happen here.
So if, Board Counsel, if it does end up with a condemnation action, the public agency does have a right to bond around the property. I would say around the property, but essentially provide a bond for the amount that they've offered to obtain the property while the litigation is ongoing. And so at that point, they do have essentially the right to the property. They have taken the property. And the litigation then becomes what is the actual value, and that's the difference at the end. It's not whether or not the public agency can take the property. They have the absolute right to take the property. It's just the value of the property that's being litigated at that point.
Okay, thank you.
Board Member Bosler.
Yeah, I just was wondering if Board Counsel could clarify your interpretation of 8610.5C number 4. It's in the board packet. It's on page 8. Page 8. So the board shall consider all the following matters, if applicable. And then lists 4 things. And the 4th one is effects of reasonably projected future events, comma, including but not limited to changes in hydrology, climate, and development within the applicable watershed.
Yes, that speaks to related to flood control. So for example, if when we speak of development, we're talking about residences or, some type of a residential development in a floodplain. That would be something that the board would want to factor in whether or not to permit it because it puts it at risk.
Including but not limited to.
Yeah, that would be correct.
Excuse me. I haven't heard any real dispute with the facts and that this project does not affect flood control. And I think we can approve the staff recommendation. If you want, I'd make that motion.
Is that a motion? And is it a motion to do it as written with 15 in the staff report, or as I was describing it? Either way, your call.
Okay. That's fine.
I'm asking which motion you're making. Yeah.
Well, I don't care. It could be either one as far as I'm concerned.
Maybe somebody else can make the motion and Joe can second.
The project does not impact flood control, so I think we should approve the fences.
No. Thank you, Board Counsel, again. I just want to remind the board that the recommendation is approving the permit in its substantial form as provided. So it it's not uncommon that conditions need to be tweaked after the board renders its decision, working with staff.
You keep asking to speak. It's irregular. What? You just tell me in like 3 words why. I think Ms. McGrego is prepared to vote.
Well, I understand that. But what the city's going to do is they're going to come in and deposit money with the court. They're going to get an order of possession. But they're never going to get the application for the bike trail over to you in 408 for years. So this fence has to stay in place until their application is approved through 408 and they come back to the board. So we need a board
Yeah, we're
meeting.
good. Thank you. I should not have brought you back up. Lesson learned for me. And we have, I mean, I do want to get everybody out. That's why I always err on this. But we also, you know, we have a process for a reason, and the Supreme Court has made decisions with less argument than this. So let's see, let's confirm that we have a motion in a second, and then we'll take it from there.
Is it necessary to have the motion seconded before a friendly amendment is offered?
I'm not sure what Board Member Countryman's motion was, but under you know the rules, the best way to do it is to either vote or for Mr. Countryman to say, go ahead.
Feel free to modify.
I propose that we adopt the recommended action from staff and include in that the opportunity to revise condition 15 as presented on screen by Member Johnson.
So you're saying before it's issued, before the permit is issued, we would look it over and decide if that words were appropriate, or?
I believe that the change to condition 15 would fit within the general spirit of what was recommended by staff. And so it's permissible, as I understand it, for us to vote on a motion to adopt the staff recommendation and still make a minor change to condition 15 as proposed on the screen right now.
Oh, 30 days is misspelled. We can do that with the correction of the inadvertent misspelling of 30 up there. And actually, I don't think that's how I wrote it because I had the actual numbers 30 in it as well. So I don't know where this one actually came from. But
Okay,
in any event, this is Board Counsel, I would like to just again, I think the fact that the recommendation is the permit is approved in substantially the form provided leaves room for any amendment to that condition as needed. And as it applies at least to this permit and this cross-levee fence, Mr. Manning has indicated that his client will remove the fence if required by the city. So I don't think there's going to be any issue there, and it's on the record.
Do you have a second?
I'll second it.
Anybody like to debate this more? I don't think so. Let the record show that Board Member Bosler shook her head. And we'll call the vote.
Member Andrews?
Aye.
Member Bosler?
Not voting.
Member Countryman?
Yes.
Member Griego?
Yes.
Secretary Johnson?
Aye. Carries with 4 board members voting aye or yes, and Board Member Bosler not voting. Okay, we will move on to 9B, which is a different version of something similar, but it is different. So we're going to we'll give people a second here to come out, and board staff can come up to the mic, and when it settles down, we'll start over again, and listen to the presentations. Slightly different facts, very similar issue. Okay, I think we're ready if you are.
Thank you, Secretary Johnson. Board members, once again, my name is Travis Comstock, and I'll be presenting another cross-levee fence. This one is the Silva and Riverside Village Improvement Association cross-levee fence. This one is in the Little Pocket area. This is item 9C. Again, my name is Travis Comstock. Next slide, please. This project proposes to install a cross-levee fence and a 16-foot wide double-leaf gate at the crown for maintenance access. Next slide, please. Again, we see the project location here. This one is in the Little Pocket, noted on the right image there at 989 Piedmont Drive. Next slide, thank you. Also on the left bank, just downstream of the West End Hotel, which we can see there, and west of I-5. Next slide, please. A little bit closer look at 989 Piedmont Drive. We can see that their property, that the fence goes across the crown there from land side to water side. Next slide, please. Similar to the last proposed cross-levee fence, this will also have 6-foot high, 8-foot wide sections. The water side will be 50 feet in length with 7 removable sections, and the land side will be 30 feet in length with 4 proposed fence sections. Again, the gate at the access point, or forward access point, is on the crowd, and it is 16 feet wide. Next slide, please. This is a typical image. We can see the water side on the left, that gate at the crown on the top there, and then on the right is the land side. There's an additional access gate there as well. Next slide, please. There was a permanent fence issued by the board in 1995. This was reissued in 96 and again in 2000, which we can see on the right here, to include Riverside Village Improvement Association. Next slide, please. Similar to the last project, there was also an Army Corps improvement project going on in this area. This one was completed in 23-24 for that Little Pocket area. Next slide, please. The applicant also took part in this encroachment removal program offered by one of our project partners to get these encroachments out of the way early and help prevent any delays to the federal project. Next slide, please. Here we can see that they did remove this fence. Next slide. While the Army Corps was conducting their work, the applicant applied for a temporary cross-levee fence on September 19th, 2023. The board did authorize a minor alteration under Work Authorization 2023-193 for a temporary cross-levee fence. And again, they have to apply for an extension every 4 months. Their most recent extension expires on July 1st, 2026. Part of their removal incentive agreement reiterated the law, Section 6 of Title 23, stating that every plan of work within an adopted plan of flood control must be approved prior to commencement of work by the board. Next slide, please. While they had their temporary cross-levee fence being installed, they applied for a permanent cross-levee fence in March of 2023. This application was sent to Army Corps on March 5th of 2024, and we received the letter of permission on May 20th of this year. Again, there will be 6-foot high, 8-foot wide fence panels on the land side, and also on the water side, 6-foot high, 8-foot wide fence panels. However, these will be removable sections of fence panel to meet Section 126A5 requirements. The 16-foot wide gate across the crown meets Section 126 B1 requirements that require adequate access for maintenance equipment. Board staff reviewed the hydraulic blockage calculation done in accordance with Section 408 categorical permission standards. The calculation came out to be 0.3% blockage for this total cross-sectional area, which was below the 1% threshold, requiring additional hydraulic analysis. So no further hydraulic analysis required. There is some ground disturbing activities. The fence posts will be installed 18 inches into the levee slopes. The fencing gates will be embedded in concrete. No seepage or stability impacts are anticipated to negatively affect the performance of the levee. Next slide, please. We can see the property owner's parcel highlighted with the red line work or red hatching. We can also see that the SSJDD easement is again highlighted in that green layer, and that the red hatching of the property owner's parcel overlays that green layer, thus requiring the need for a permit application. Next slide, thank you. Board staff did conduct CEQA analysis, again under Title 14, Section 15-300, using the list of classes of projects that are determined to not have significant impact on the environment. This project fell under Class 2, replacement or reconstruction, Class 3, new construction of small structures, and Class 4, minor alteration to land. The local maintaining agency, MA9, did endorse the project in March of 23, and we received the Section 408 letter of permission on May 20th. Next slide, please. Once again, the board is granted authority to regulate the levees under Water Code Section 8534, 8590 through 8610.5, and 8710. Specifically, Title 23 gives the language for regulating the need for a permit, the endorsements and variances, as well as Section 126, the fences and gates pertaining to this particular project. Under Water Code 8610.5, staff asks that the board consider the following: that hydraulic blockage calculation conducted by the applicant meets Army Corps and board standards and demonstrates that the proposed encroachments will have negligible effects on the conveyance of flood flows, that the proposed project was coordinated and reviewed by Army Corps Section 408 as well as Army Corps levee safety, and they found that there will be no impacts to the performance of the levee as a result of the proposed work. And the proposed project is not anticipated to result in any adverse effects on facilities of the SPFC under currently or reasonably projected future events such as water surface elevation rise and the result of changes in hydrology, climate, and development in the watershed. Again, in trying to be consistent with these cross-levee fence applications, we did apply the two special conditions. Again, here's condition 14, stating that the permittee acknowledged that their encroachments may interfere with future maintenance, inspection, emergency response, construction, rehabilitation, or other authorized projects, and upon written notice from the board, the permittee shall remove these at their cost and expense. Next slide, please. And again, special condition 15, that under change of property rights affecting the encroachments herein, this permit will be revoked or modified as determined by the board. With that, board staff asks that the board adopt the CEQA findings, approve permit number 19806, and direct the executive officer to prepare and execute the permit and file the notice of exemption with the state clearinghouse. Any questions?
Any questions? Okay, thank you very much. And then we'll ask to hear from the applicant.
Mr. Johnson, I want to make you very happy. I have nothing further substantive to say, but I do have a few introductions. So this is James Silva and his wife, Karen Silva. I represent them. This is Rebecca Westmore. She is the president of the Riverside Village Improvement Association, Inc. This is John Brophy. He is the committee chair of the East Gate. It is his responsibility to make sure it is properly maintained. He has information, if you want to hear from him, about the Knox boxes, what they do, how they work, how to get the fire department out there, if you want to be educated on that today. Other than that, I have nothing further to say. Any questions?
Thank you. And thanks for coming and for the introductions. And reading the room, I think. Public comment. Do we have, I don't have any cards for 9C other than yours. Do we have anybody here in the room who would like to speak to 9C? And online?
No hands raised online.
Okay. We'll close the public comment and come back to the board for a discussion and ultimately a motion.
Are you making a similar a modification to number 15?
That's my recommendation.
Yeah, that's my. I would support that.
Is that a motion, or are you just saying you support it, and we'll see when we have the motion? Yeah. We've had so much discussion before motions on other ones. I think we're ready for a motion here on this one, to be honest. Yeah, everybody's nodding, but not from Keeley, perhaps.
You didn't like my last motion, so I'm hesitant, but I'll make a motion to adopt staff recommendations.
All right, we have a motion.
I'll second it.
And it looks like Board Member Andrews may want to discuss the motion, so I'll make sure I pause for that step.
I simply wanted to suggest that while I'm supportive of implementing the staff recommendation, largely, I also think that the same modification to condition 15 would be appropriate to make on this permit as we did on the prior matter that we discussed.
And we've heard that the staff substantial covers it, but I have the same sense. We heard Board Member Countryman earlier say he doesn't care. So, all right, we'll call the roll.
Member Andrews?
Aye.
Member Bosler?
Not voting.
Member Countryman?
Yes.
Member Griego?
Yes.
Secretary Johnson?
Aye. So that one also carries with 4 votes affirmative and Board Member Bosler not voting. Do we need a break? Can we just keep rolling? We're going to keep rolling. Okay. Thank you for coming, and we'll move on to agenda item number 10. So we have a normal item here, always 10A for the written report, and we all have that. I will ask to see if we have any comments, question, discussion that the board would like to have about the written report or anything from the room. Not seeing anything, we'll go to 10B, which is 2027 Central Valley Flood Protection Plan update, and Mr. Chris Williams. Thank you.
All right. Good afternoon, Secretary Johnson, members of the board. My name is Christopher Williams, Department of Water Resources, Division of Flood Planning and Improvements. So as we like to do in the final year before the plan is adopted, it's on a 5-year update cycle, we like to up the amount of time that we spend in front of the board on various topics that build into the plan. And so today, my presentation, if we could go to the next slide. Okay, so today, and I know it's been a long afternoon, so I promise you this is going to be pretty brief, but pretty pointed. I want to share with you the schedule that we're working on for the next plan and the progress that we've made. And then I'm going to turn it over to my colleague, Chong Vang. He's going to talk about a very important piece of the technical analysis, which is the flood exposure updates. And this is the piece that deals with the inventory that's sitting out there in the floodplains and the people that are at risk and being protected. and some changes, very important changes that we're making for this next plan update to those key topics. And I just want to also say that before we get into this, that part of this is that, the CVFPP, one of the pillars of each 5-year update is that we try and use the best available science. We try and include all the recent technical advances and the latest tools that we can use to provide the measure of flood risk and H&H, hydraulics and hydrology and all these pieces. And so this is just another piece of that. So next slide, please. So as you all know, the CVFPP is the comprehensive system-wide flood management strategy for the Central Valley, updated every 5 years. Another key thing is that 5 pieces of each plan update every 5 years are things that we update, and it can be divided into these 5 areas. We have technical, which is the important piece that we're going to be talking about today. We have some important milestones that have been reached. The hydrology is essentially done for both basins, the Sacramento and the San Joaquin. And we are working on the hydraulics right now. They have been done for the San Joaquin, and we've been working very diligently to get them done for the Sacramento basin. A lot of progress has been made on the climate and the watershed analysis. We're working on the baseline conditions and the with project conditions, the elements that are going to affect the hydraulic analysis. And all of this is to better reflect the risk and consequences throughout the system. The other piece is the conservation strategy. As we reported on over the last several years, for this update, we are going to be integrating all the components of the conservation strategy into the document itself. We've been making a lot of progress on that. A lot of it is revolved around the new CVFPP online portal that we're going to be developing and all the tools that are going to be put into that portal to help integrate conservation elements into the portfolio of actions for the CVFPP. We also work on the investment strategy, and this is the gathering of the project list that goes into our portfolio, working on the funding plan, the phasing, the implementation, and the delivery of those projects. For this next update, so I think we've reported already to you folks, we are working on a new financial model, a new funding model, based on all new tools and software, and very different than we had in 2022. Super important piece, regional coordination. So we all know that we have reduced funding and resources for our RFMP, our Regional Flood Management Program. We've been working really, really hard to keep those lines of communication and coordination substantial between our regional partners. We do have monthly technical meetings this time around. That's been a huge help to try and pull down that curtain before the technical results are wrapped into our public draft. Those have been going well. We also have quarterly meetings with the regional partners on a basin category. So we have the 3 regions from the San Joaquin and the 3 regions from the Sacramento. Attend those meetings, and then we also have periodic interactions with our regional partners at the coordinating committee and the advisory committee, and then other meetings as needed. But like I said, we're trying to leverage this the best that we can, but we all know that resources have been not where we want them to be. And so we do obviously advocate for increased awareness and funding for regional planning. That's a huge piece. And then the last I want to talk about is the flood system inspections that feed into our descriptive document and our flood system status report. This 2027 update is going to be based on the 2025 inspections, which are complete. And then on this slide, the last thing I want to talk about is all these pieces are fitting in, and they're brought together, obviously in the update itself, but then also this time around, we're doing that CVFPP portal piece, which is new. And then we will also, as we've done in 2017 and 2022, we will be doing the technical summary report, which is basically all of the technical work, the outcomes, the key messages from all of the technical technical memorandums that are put together. That's going to be coming out, as well as, like I mentioned, the flood system status report and descriptive document. So next slide, please. So before I turn it over to Chong, this is the last slide I have for you. High level, this is the schedule that we're working on right now. All of these key pieces are marching towards next year, Q4 adoption of the flood plan. The piece at the top the CVFPP portal. Some of the work that we've been doing this year, the first piece of that to unveil was our management action tracking system, which was where our regional partners would input any changes to the projects that they have within their regions. That was earlier this year. We got a lot of that interaction done, and then most recently we've been working with them on key pieces of the conservation strategy on the portal. Throughout this year, towards the end of this year, we're going to be doing some work on the data viewer and the report creation that's going to be a piece of the portal, and getting some of the final pieces wrapped up so that we will, marching towards when the actual flood plan is adopted, we hope to have a public-facing version done of the portal. So basically this last year has been a lot of the draft pieces of the portal and the beta testing is being done. But I do want to point out, like I show the arrow continuing here, unlike the final adoption at the end of next year of the plan itself, the portal we're hoping it's going to be living on. So a lot of the improvements we'll be making after, during each 5-year cycle, even after the adoption of the 2027 plan. On the plan itself, some of the key pieces you'll see here on the very to the left, the regional section we have, as we did in 2022, we wanted to capture a lot of the regional priorities and perspectives to put in the plan. So for 2027, we did earlier last month ask the regional partners to, we sent them a draft of kind of like their highlights to ask them to weigh in and give us some feedback on that. Their input is going to be integrated into basin chapters. One of the things that is different this time around, in the past we've had 4 chapters of the plan, we have basin-specific chapters this time. We are going to be giving the regional partners a beta view of the basin chapters for their review and input before the public draft comes out. The public draft, as you see on the schedule here, is going to be scheduled for February of next year. And that'll be pretty similar to what we've done before, like a 45-day comment period. Board collecting, holding workshops, collecting comments, and then all of this is marching towards the final draft of the plan at the end of the year. The technical, as I mentioned before, a lot of the H&H has been completed. The actual results are going to trail the basin chapter just a little bit. We're hoping to have those in the hands of our regional partners next month. And then later in the fall, we're going to have the expected annual damages and the expected annual life loss calculations based on the inventory that Chong's about to talk about done. The technical analysis summary report, as well as the last item here, the flood system status report and the descriptive document, are going to be out at the same time as the public draft. They're going to be out for public review and comments. The status report and the descriptive document, we expect similar to before. There's not a whole lot of changes that happen with them, but they will be out for public review as well. So at this point, that's the only slides I have for you on the schedule. Before I hand it over to Chong, I want to pause here and see if anyone has any questions on what I've presented.
Board Member Bosler.
I don't have any comments, but I just want to say kudos to your team, you and your team, for all the hard work that you're putting into it. I think these plans matter. It's partly why I was not able to support the last 2 motions. And I think we need to really think about how we align all of our individual actions at all the different regulatory boards and commissions across the state with plans and how we can accelerate their movement forward. And so, I mean, I just think this matters so much for the flood community in the Central Valley, and just really appreciate all of the careful attention to it.
Thank you. Thanks.
Yep, thank you for that. So I'm going to turn it over to Chong Vang.
Yep, welcome.
Thank you, Chris. Board Member Johnson, Secretary Johnson, members of the board. I'm Chong Vang with California Department of Water Resources. I work directly under Chris Williams in our flood planning branch, and I'm here today kind of present to you at least an update of the flood exposure that we are using currently in our Central Valley Flood Protection Plan 2027 update. And so with this slide, kind of grounding us into the components of flood risk that you see here. In Central Valley Flood Protection Plan, risk is kind of driven by 4 link elements. And you can see here on the left side of the screen, it's the hazard, essentially the state plan flood control system, which is kind of composed of rivers, bypasses, and weirs. The performance essentially is the infrastructures that protects the people and property within the floodplains. And then linking our exposure with essentially who and what is at harm's way and assessing the vulnerability. And that in itself ties into the consequences. So today's presentation of the exposure of who and what is harm's way is because the exposure is the foundation of our consequences calculation. The floodplain inventory defines our exposures and feeds directly into our economic damage analysis and also our life risk analysis. That inventory is the data sets behind our numbers, like where people, structures, crops, vehicles, critical infrastructures are located relative to the potential flooding. Right? It's the baseline for how we estimate damages and potential lives saved as we evaluate the strategies. So as we move forward to refining the 2027 risk analysis, it's important for the board and others to have visibility into the foundation data sets that we use within our work, at least essentially the technical analysis. The inventory is central to understanding how risk changes over time and how these improve or proposed system improvements, structural and non-structural, translates to the benefits for life saved, essentially life safety and economic resilience. And so diving into why the inventory matters, essentially, right? Risk to people and property living near or behind levees continues to increase. That risk is driven by population and structural growth, right? Changes in land use, and the fact that we have better tools and data to take a snapshot of what's on the ground, at least on a 1,000-foot level of what's on the ground. That inventory is critical to the building block of the Central Valley Flood Protection Plan, and it keeps our understanding aligned with today's conditions. So next slide. So just common floodplain management decisions, right, that we consider, the flood risk inventory and updated system performance information directly feeds into these core decisions, right? Funding, which is one of them. Essentially, what's the long-term value of system improvements or levee maintenance investments? Trying to answer that questions. Exposure essentially provides more clarity that helps direct limited or at least access of fundings to where they deliver the greatest system-wide benefits. Consequencing, which is essentially trying to answer what's the best order of repairs and improvements. Our inventory that we use in the 2027 update essentially helps and shows us where risk analysis shows where the consequences are highest today and what we can implement so we can implement the right projects at the right time and align with multi-benefit opportunities and socioeconomic drivers. So evaluating, right, what public safety benefits will a project or management action deliver, right? Clear exposure paired with the hazards and the performance modeling lets us compare alternative consequences analysis. Also be able to quantify life risk reduction and align investments with statewide policies and programs. Next slide. Just going through the data sources and some of the improvements for the 2027 update. Before I kind of cover through the floodplain coverage of what we're using over the following slides, I just want to kind of give you a quick summary of the data sources for it. Each of these data sources represents an improvement in accuracy and completeness and geographical coverage from the previous updates. You can see here we have listed on five key items, or at least data sources that we are using. For the 2027 structural update, we are using the 2022 CVFP update, or baseline data sets. Within that effort, we went through a comprehensive data collection, working with our federal interest partners of getting this California structure inventory. And so that becomes our baseline data sets. And we use the following ones, the National Structure Inventory, to kind of improve and update our inventory that we currently have right now. And so that is considered the NSI 2022, along with using parcel data that we collected through our department description or Lightbox. And then I'll follow that up with the 2010 or 22 census data with other improvements to use to update population. And then we use our DWR 2024 statewide crop mapping data sets to identify areas within the floodplain of crops. So these inputs helps eliminate duplicates, right? Fill in the gaps, correct underrepresented areas, and importantly, align assets correctly to the expanded footprint within 2027. So just what is in the data? This is kind of my disclaimer as an engineer, putting my engineering hat, a disclaimer of what the data is and what the data is not. And so before viewing the footprint, right, just a quick overview of it. Essentially, the floodplain risk data, what's included in there are structure data, there's population data, crops and farmland, vehicles, road segments, and then business loss, potential business loss and emergency costs, and others. Right? These input set feeds directly into our economic damages, life safety modeling, and system-wide comparisons. Now, what the data set is not, it is not a flood model, right? It is not a consensus level audit, even though we are pulling out a lot of census data. It's not a substitute for what's actually on the field, or at least on the ground, because we are not doing a comprehensive survey of everything that's on the ground. It does not represent market values, even though we are putting prices on these structures. And finally, it's not a final depiction of the consequences. Right, it is a snapshot of what exists in the mapped floodplain that's used in combination with the hazards and performance in our computation of risks. Next slide. So looking at the map of this slide, you see two maps, one in the middle, one in the right. The one in the middle represents the Sacramento River basins. The one on the right represents the San Joaquin River basin. And within the two maps, you can see three different color shades. The purple is essentially the map of the boundary that we use in our technical analysis for 2022. And then you see a blue, darkish bluish, blue, you call it blue, that kind of goes beyond the purple map. And that is our expanded footprint for the 2027 update. And you can see a few smaller areas of yellow, which is the additional new areas that we included for the 2027 update. Now, you can ask why we're expanding this and to kind of get you on the 5 key points of why we expand this footprint, right? Because of updated hydrology and climate impacts. If we are evaluating within the Central Valley Flood Protection Plan climate and future climate, we have to expand that footprint. And so that means that we're evaluating these climate extremes of climate change, then we have to expand the footprint so that we can follow where the water is going if it goes in the floodplain. So that is part of our recommendations from the last update that we received from our technical team and from others. Also, for the second bullet point, modeling, improved modeling. Our models that we use today is better than what we had 5 years ago, which means that we're not limited by the tools. We can use this model to run more faster, more efficient, and there's been better improvements of these models and tools.
Excuse me. I'll ask this question rather than waiting till the end. I'd like to make sure I understand the difference between the new impact areas and the expanded impact areas.
Yes.
Maybe just go through it again. I'm sure it's there, and I'm just being a little bit slow.
Yeah.
Thank you.
The impact area is essentially what we evaluate what's in the floodplain, right? And then essentially the 2022 areas is what was carried over from the previous comprehensive study that we used within the 2012 and 2017 and 22 updates. And so when we evaluate flood risk, we evaluate flood risk within that impact area. And so for 2027, we expanded that impact area to a greater extent. And so that's why on the San Joaquin side, if you look on San Joaquin, you see more areas that have expanded to east of the valley, essentially. And that will kind of help us capture when we use our data and tools and the information that we do have to kind of represent those areas that if it gets flooded, we can capture those floodplain areas.
So this looks like a no levy evaluation of some kind.
Well,
I can't see any levies in there.
Well, the levies are included in there. Essentially, this is a high-level view of the extent when we evaluate part of the consequences of flooding. So the performance of the levees too.
So it's not an expanded floodplain. It's expanded area of analysis.
Correct, that's
Thank
correct. Yes, it is an expanded area of the analysis, essentially, that we're using.
Thank you.
And so that's kind of like my third point, right? It is an expanded area of our analysis just because of the data sets that we do have today can help us expand that out. I think before in previous updates, we were limited by topography data. We can only evaluate topography data as far as we go. And there's been collection efforts within the 2021 from Department of Water Resources and the board to collect data sets within the San Joaquin River basins. And so we are using that data sets that essentially goes all the way up to always up to the reservoirs. And so that's why the expansion within the San Joaquin River basin has increased, just for the technical analysis itself.
It is an impact area.
It is an impact area which we increase, and we added into analysis. And so some of the yellow areas, which we highlight in the Merced area, Davis, Woodland, and Chico, those floodplains has already been there. We're including those floodplains in the technical analysis as far as, as a starting step to get additional data sets of the exposure, the inventories behind it within those floodplains. And so essentially that reflects system performance and any land changes that we can capture for this 2027 update. Next slide. So just kind of provide a high-level overview, right, of the floodplain inventory that the team has collected within the two basins. Again, you see a map of the Sacramento River basins and the San Joaquin River Basin, and the two tables that's shown on there. One of them is the Sacramento Basin, the other one's the San Joaquin Basin. And just going through some of the numbers, or at least what's shown, the first column is the inventory and the structures. The second column, what we call the 2027 inventory, essentially with the technical analysis, when we expand that footprint to 2027, what is in there. So you can see the inventory area that's covered within the 2027 technical analysis is about 1,586,000. And then the number of structures after the data collection within the Sacramento River Basin is about 408,000. Now, the third column itself, it's within the 2027 footprint. What has changed? Essentially, how much has it changed, if it changed? And so that's why the inventory area is still the same from 2027, but the number of structures within that same 2027 footprint has increased by 3%. And the fourth column, which is the percent change from the expanded footprint, is within the technical analysis. When we expand that footprint, how much has driven up that number within column 2. And so that's why in the Sacramento River basins, the inventory area has increased by 30%, expanding outside from 2022. And with that expansion of 30%, the numbers of structures has increased about 32% because we expanded the footprint of our technical analysis. But yet again, like I said, this is just the inventory. It does not mean that communities or those expanded areas is at flood risk. We haven't gone through that yet. And so within the San Joaquin Basin, same thing with the inventory areas and the number of structures. Right, inventory area has been 1,097,000 from 2027. The number of structures that we estimated out to be about 233,800, just all structures, and I'll get to that, what those structures are in a bit. And the percent of growth within the 22 footprint, you can see the area covers the same, but the structures has gone up by 70%. And then from the 2027 expanded footprint, you can see we increased that area by 51% from the previous update, and the structures has gone up 170% because of the expanded footprint. And so just to remind everyone, right, the dollar values that we put on there, it is from Q2 of 2025. So it's not complete, but it's what we can grab from the latest data sets that we do have, which I listed out from the previous slides. So the next slide. So jumping into the Sacramento River Basin, right? Within the structural category, you can see there's commercial, industrial, public, and residential. And then from column 2, you can see the 2027 structure count. You can see how much structural count it is from each of those 4 categories of structural, industrial, public, and residential. third column, same thing. The percent of growth of the 22 footprint of those structure categories. And the column 4 is the change because of the expanded footprint. And so essentially in 2027, our structural count is 408,000. You can see the greatest number of structure are residential structures, which is at 369,600. And that is an increase because of our expanded footprint, because of 32%. Now, if you look at the second table on the bottom, right, it goes through the dollar values of it, from commercial, industrial, public, and residential. All of those total about $170.1 billion of assets within the Sacramento River Basin, within our tech analysis footprint. And so you can see the percent of growth within the 22 footprint, it's pretty consistent, about 30%, 20%, 31, 43, 22, 28, so within the 20, 30%. And then within the change of the footprint, it's greatly increased, right, depending on which structure inventory it is. And so go to the next slide. So just some key takeaways, right? Sacramento essentially shows modest or minimal structural growth in the 22 and 2 footprint. The largest increases is in the commercial or residential, and there's moderate values increase due to the expanded footprint and inflation. And so there's moderate increases, about 30% in inventory value, like I said, due to inflation or increase of structural and industrial values. Question, go ahead.
I think I understand it, but just to clarify, I live in Natomas. So there's been a lot of growth in Natomas.
Yes.
So what you're saying is this includes, that was in the 2022 also, Natomas. I
Yes.
think that area was included.
Yes.
So whatever growth was in there was, if we look at that, that's not because you expanded the area. That was in the area for both, right?
Yeah, so if you go back one slide, it'll have two, right? One's 2022. If I would keep in the 22 footprint, you can see the growth.
Yes.
Within 2022. And then the other one is expanded, and so it's additional.
Wow.
So it's part of the 2022, like 30%, essentially you average it out,
Yeah,
30%.
yeah.
30% could increase in Thomas, and then the 78% is increase of the expanded area that we included now.
I got it.
Yeah.
I guess I'm a little surprised that there was that much development outside the 2022 floodplain. It seems, when I look at it, it seems like that's mostly rural areas.
Well, I mean, it's not development, but what we're including now. Those areas has already been in there in 2022, but we didn't include it yet. Meaning there's already areas or buildings outside of our 2022 footprint. And so we're including it now for this 2027 footprint. And the counts are into our 2027 footprint. And so I'll get to some of the regions too, and you'll see it. And so going to the San Joaquin. So same thing, same exercise, right? The map on the right is the San Joaquin River basins. You can see on the purple area shows you 2022 impact area footprint, the boundaries. The blue one is the expansion ones that goes beyond the 2022. And then the yellow is the additional 2 that we included in 2027. And so looking at the structural counts or structural categories, right? Commercial, industrial, public, and residential. All of those total up to be about 233,800. And the greatest is in the residential areas or residential structures. And so within the 2022 footprint, you can see hasn't been much growth, no matter which category you look at it. Right? Residential is only 8% growth within the same 22 footprint. But if we look at any of the purple areas, essentially, because of the purple area, we included 107,000 more. So that's what it means. Yeah. And so looking at the dollar values of, the dollar values, which we calculated from the quarter 2 of 2025, all of those dollar values within, or these assets within the San Joaquin River basins comes up to be $123.5 billion. And most of those are in the residential structures. And you can see the percentage of growth within the dollar values, kind of average about 38% within those four categories. And because of the expansion of our 2027 footprint for our technical analysis, it's kind of gone up by 256%. Like I said, meaning even though we include this as this assets within the floodplain, does not mean there are actual damages. And so that will come later on during future presentations. Next slide. So key takeaways from the San Joaquin River Basin, right? So San Joaquin itself reflects minimal increases in structures inside the 2022 footprint, like I stated earlier. The largest growth is in the industrial and residential, 8% each of those. And a significant overall value increase to the expanded footprint. So there is moderate value increase that stems from inflation and structural growth. And so, like I said, at least a moderate one based on commercial industrial. So next slide, looking at the regional overview, I think, kind of get to your answer, board member and countrymen, right? The structure counts within each of the different regions. Within the Central Valley Flood Protection Plan, we highlight six regional, 6 regions within CVFPP, but 3 in each of the regional, 3 regions within each of the basins. We have the mid-upper Sacramento River region, the Feather River regions, the lower Sacramento Delta North region, and then you have the lower San Joaquin River Delta South region, you have the middle San Joaquin region, and the upper San Joaquin region. And so you can see, based on our total 2027 structures, second column, the highest structure counts is in the lower Sacramento and lower San Joaquin areas, while as mid-upper Sacramento and Feather, right, those are smaller compared to the lower ones. And then you have middle San Joaquin and upper San Joaquin, those are lower than the lower San Joaquin Delta South. And so then we're looking at the percent change within the 22 footprint of each of the different regions. It goes less than 10%, so the highest 8% is in the lower San Joaquin. So there's been 8% growth within the lower San Joaquin Delta South region.
Sorry, I'm just kind of astounded. So what you're saying, this expansion includes areas that in your purview is subject to flooding. I mean, why would you expand it if you didn't expect that there could be flooding there?
Well, there's a chance, there's a possibility, right? When we try to evaluate future climate change, it could be a possibility. And so we didn't want to run our analysis and find out that it's restricted because, it's going beyond it. And so
I see.
We just include it.
You're going to overlay your floodplain analysis on this grid.
Yes.
It won't be filled out all the way to
Yes.
Okay, I got
it. Just for being conservative, we want to collect as much data information we can now, so when we run our analysis, it doesn't become a limiting factor to the analysis.
Yeah, this is Christopher Williams, DWR. One of the ways that I would look at this is that, we are looking at communities and properties that are protected by state plan of flood control facilities and or influenced by the operation of facilities of the state plan of flood control. So when you look at a lot of these maps have their origins back to the 2012 plan. And as we are, population has increased and just our understanding, our modeling is showing, hey, there's this other area that could potentially, as Chong said, we don't know yet as far as there's going to be damage in that area, but it could be potentially influenced by and there could be inundation there. And so that's why, it's just that you would expect the maps to change. And we took a really hard look at that for this next update, and that's where we're at. So
it's just, this is providing the underlying database that you put the floodplains on that you're getting. So I got it.
That's correct. I think just one last slide. So next slide, just the key takeaways from our flood exposure ones, right? And just to kind of summarize it up. So, to keep in mind as we continue to complete the flood risk analysis, right? The data sets, it is an improvement to the data sets, and the technical coverage expansions are significant drivers of change within the floodplains. Like population and structures continue to grow, and so that's more heavily in the residential urban areas. They're leading that pack. Our estimates, like I said, estimates in assets and dollars as shown does not equal to damages. They are just exposure inputs, right? The consequences that we use in our technical analysis depends on the hydrology, hydraulics, levee performance. Kristen was talking about system, operations, warning, and response. So that's just the key. These are just key inputs to our analysis. And just a final disclosure, right? The inventory is subject to change as we continue to complete our analysis and present our findings to the board. With that concludes my presentation. Any questions?
Thank you. This is fascinating. And it just goes really to the heart of what we're trying to do with the flood plan, right? And looking forward to hearing more about the implications of this information as you do the overlays and what it'll mean for risk and value protected by the state plan of flood control and future choices to make and all this. Comments, questions from the board? All right, thank you.
Thank you.
That was 10B. And, oh, yeah, I got to get public comment. Do we have any public comment? I was so close. Online?
None online.
There's no public comment. So that was 10B. And now we will go to 10C. And we have Justin Logan with DWR to walk us through. And this is an action item.
Okay. Good afternoon, board members, Secretary Johnson, and board staff. My name is Justin Logan. I am an engineer with the Department of Water Resources, Delta Levees Maintenance Subventions Program. Also here joined with Andrea Lobato and Sandy Maxwell from the Delta Levees Program as well. Next slide, please. Next slide. Thank you. And this should be a fairly short presentation, 7 to 8 minutes. So today I am here to talk to you about the Delta Levees Maintenance Subventions Program and to ask your approval of the subventions fiscal year 24-25 estimated reimbursements, the subventions fiscal year 26-27 funding plan for $16 million, and the preparation of the fiscal year 26-27 work agreements. Next slide. Next slide, please. Thank you. As you know, the Delta is one of California's most important geographic regions. In one way or another, almost every Californian relies on resources that comes from the Delta or passes through it. Next slide. The Delta is far more than just a water resource, vibrant farmland, or crossroads of infrastructure. The Delta provides critical habitat for countless plant, animal species, from migratory birds to native fish. It is also a place where people live and recreate. For over 50 years, the subventions program has supported LMAs in maintaining their levees and protecting the Delta. Next slide. The Delta levees have withstood daily tidal fluctuations, changing weather conditions, excess and unwanted vegetation growth, burrowing animals, trespassers, and more. The integrity of this levee system is critical to California, and is why the subventions program is so important. The subventions program invests annually in the maintenance of the levees to maintain and preserve the Delta. Currently, over 70 local agencies participate in the subventions program with maintenance and rehabilitation work involving both project and non-project levees. Next slide. We are currently funding fiscal year 24-25 reimbursements, for which the board has approved $16 million of funding. We received 71 final claims with over $17 million in claimed work. We are currently in the process of reimbursing a little under $12 million. The local cost share for that is around $5 million. Next slide. The LMAs are currently wrapping up fiscal year 25-26 maintenance activities with up to $16 million for reimbursements approved by this board as of last year. Any unspent funds will then be rolled into future years' funding. Final claims for fiscal year 25-26 reimbursements are due by November 1st of this year. Next slide. This past April, we received 75 applications. This is work that the LMAs will be starting on July 1st of this year and continuing through the end of next June. Final claims will then be due in November of 2027. We are proposing a funding plan of $16 million. We believe that a funding plan of $16 million meets the needs of the LMAs. If reimbursements don't go past that amount, any unspent funds will be rolled into future years' funding. Next slide. While we still have Proposition 1 funding available, Proposition 4 funding will most likely be used to support subventions program reimbursements starting in fiscal year 25-26. For 26-27 claims and onward, Proposition 4 funding will be the primary source of funding for the subventions program reimbursements unless other funding sources become available to us. Due to Prop 4 restrictions, any costs associated specifically with environmental mitigation must be covered by alternative funding sources and not Proposition 4. Our program is planning for this, and we don't currently foresee any issue with being able to reimburse for required mitigation. Next slide. An update to our guidelines is being initiated to address the unique restrictions of Proposition 4. Aside from Prop 4, the current set of guidelines were last updated by this board in 2016, making them nearly a decade old. We have been considering an update for several years, and the need to incorporate the Prop 4 provisions provided us the right opportunity to review the existing guidelines and make revisions that reflect the evolving economic and environmental issues facing the Delta today. The updated document will aim to provide clear direction for program eligibility, application procedures, and funding criteria which allow flexibility for the future. We anticipate having updated guidelines ready to present to this board sometime in early 2027. Next slide. So because the Delta is so important to California, this board, CDFW, the LMAs, and DWR all work together through the subventions program to help fund, maintain, and protect the levees of the Delta. For over the last 50+ years, this annual investment has ensured the integrity of the levee system while also protecting and preserving California's water supply. It is a long-standing partnership that continues to support the Delta and millions of people who depend on it. Next slide. With that said, DWR staff recommends the board approve the fiscal year 24-25 estimated reimbursements, which is Table A in your report, the fiscal year 26-27 $16 million funding plan, which is Table 2 in the report, and to approve the preparation of the fiscal year 26-27 subventions program work agreements. And with that, I conclude my presentation and open it up to questions if there are any.
Thank you. Questions from the board? Not seeing any questions from the board. We will go to public comment. Is there anybody in the room who would like to make a comment? There is. Please come to the microphone and state your name for the record.
Thank you very much, Secretary Johnson, members of the board. My name is Michael Moncrief. I'm with MBK Engineers. I'm here today on behalf of the Central Valley Flood Control Association. And this is an opportunity for us to annually just appreciate the board and the state. The subventions program, as Justin stated, is a critically important program that supports so much of the values of sustainability, of flood control, agriculture, and all the various multi-benefits that the Delta provides the state. Just looking back to 2018-19, the program has provided funding for up to $112 million in claims through the 24-25 program, which has provided $75 million in reimbursement. Local agencies, they submit this as a reimbursement. So funding comes back to them for eligible expenses anywhere from 12 to 18 months in arrears. And it is a 75% maximum reimbursement, but typically what we see, the reimbursement is around 60 to 65%. Sometimes we get into the 70% reimbursement range, but all of the local assessments and contributions by those landowners into their RDs help provide that funding to do this critical maintenance and minor repair work to ensure that the flood control system throughout the Delta, which includes about 250 miles of project levees that are eligible in this program as well, are maintained and continue to progressively work on their issues. So I'm just here to support the association, saying thank you to the board for administering this program. Thank you to the state, Justin, Sandy, Andrea, for the many years of service, and we continue to support the program and the board moving forward. Thank you.
Thank you for coming. Anybody else here in the room? And any comment online?
None online.
Not seeing any more comment. We'll bring it back to the board for discussion if you have any, and motion.
I'm ready to make a motion.
Board Member Gregg, I'll go ahead.
Okay, I'll go ahead and make a motion to approve as staff recommendation.
Do we have a second?
I'll second that.
Moved by Board Member Griego and seconded by Board Member Bosler to approve the program according to the staff recommendation. Any debate on the motion? And we'll call the roll.
Member Andrews?
Aye.
Member Bosler?
Aye.
Member Countryman?
Yes.
Member Griego?
Yes.
Secretary Johnson?
Aye. And that carries. Thank you. Yeah, the ayes have it. Sometimes the yeses have it. All right. Thank you for coming. And we're going to move on to our next items here. Staff activity reports. As usual, we have those in our briefing packets in writing, and we appreciate those. Any comments, questions, additions from board members on those? Public comments?
I have.
Oh, yeah. Board Member Countryman.
Under board comments, I received a contact from people who live along the Chowchilla Canal bypass in the San Joaquin system. And there, as you recall, we've approved some diversion structures. During flood periods, you can take water out and put it into groundwater basins. And they're struggling a little bit with the Water Control Board as far as a water rights issue. And they called me because they felt like I was an expert in what constitutes floodwater. And I mean, my response was, I don't speak for the board, but any water that's in Chowchilla Canal bypass is floodwater. Anyway, it's an issue that they may be coming to the board for clarification as far as what they're telling the Water Control Board what constitutes floodwater. So I just wanted to alert you that I did receive that contact. I recommended they contact Chris, and if they wanted to, follow up with what's possible that the board might be able to weigh in here. But since we're strongly in favor of these multi-purpose projects, I feel there's some way that we can make this work. Anyway, that's my report.
Thank you. That was Board Member Countryman, and appreciate you giving us a heads up about that. That's a hot topic everywhere. Other board comments, committee updates for item 12 here? Okay. I have one brief one, which is earlier this week, I attended a reception for Secretary Nemeth with DWR staff and some people from CNRA and other partners as she prepares to depart from DWR and to our next thing. And I just want to recognize her service and maybe join me in thanking her for the work she did for the state and offering best wishes for what comes next. Board Member Bosler.
Your ears must have been burning because I was just thinking about her listening to the Delta Levees presentation. She's been such a joy to work next to and with on water issues. She's made so much progress in her time here, and I'm very, very, feel very fortunate to have got to work with her so closely, and I'm sad to see her leave, but I know for all of us there's a time to leave these important and huge responsibilities that she has on her shoulders, leading the Department of Water Resources. But I know she will continue to do good work in the water world, but man, she's just been such a force for good and forward-looking for the state and for our ever critical resource, our water resources. So I'm just, I want to second your notes of thanks to her.
Thank you. Public comment on the board updates? I'm supposed to do that? Yeah. Okay, upcoming meetings. We have Coordinating Committee, July 21, West Sacramento City Hall. We have, they're on the screen here, board meeting, July 24th, back here. Board workshop, August 21st, with some uncertainty about exactly how that'll go, so stay tuned. And advisory committee, August 25. And that brings us to the closed session, which we do have today. So I'm going to turn to our board counsel to tell us how that's going to work.
Thank you, Secretary Johnson. We will be meeting today in closed session, first to discuss the litigation matter American River Trees et al. Versus the board in District Court, case number 225 CV 02384. And then secondly, I will be requesting action from the board pursuant to Government Code 11126 subdivisions E1, E2BI, and E2CI to consider potential litigation involving the board.
Thank you. And if we have an action item, we will report that back, and if we don't, we'll report that as well. And with that, we'll go to closed session. Do I get to hit this thing again? Yeah. Welcome back. Closed session is over. We're back here for a report. I'll turn to our board counsel, Jeet Dua.
Thank you, Secretary Johnson. On the matter of the American River Trees versus the Central Valley Flood Protection Board, there is nothing to report. On the matter of potential litigation, the board has authorized board counsel to refer an enforcement matter to the California Attorney General's office for prosecution and hopefully attempted compliance. End of report.
Thank you. And that concludes our meeting. 3:30 exactly. Thank you all.